that
Yes.
today is not a mentioning day, my lord, but under my lord, extremely compelling circumstances, my lord, and with utmost humility, my lord, may my lord mention, my lord, matters pertaining to my lord, the circuit bench at Jalpaiguri, my lord, having lordship's determination, my lord. Lordship knows, my lord, that the Jalpaiguri circuit bench is not in session as of now, my lord. But these pertains to my lord, only extension of interim orders, my lord, which are due to expire, my lord, tomorrow, 28th, my lord, of February, my lord.
Jalpaiguri Circuit Bench.
Jalpaiguri Circuit Bench, my lord.
Within my determination, how?
No, it's pertains to lordship's determination, my lord.
Group 8 matters.
Group 8 matters. My lord, all notification matters. All notification, lordship, like lordship has given, my lord, till the pendency of the appeal, my lord. In Jalpaiguri, my lord, the interim order was passed till 28th of February, my lord, which is expiring to an.
Who passed the interim order?
Shogato Bhattacharya.
Okay.
Under extremely completion, my lord.
So you mentioned this matter before Mr. Justice Bhattacharya.
No, my lord. It has to be before the judge, my lord, having determination of that matter till such time that the second bench does not sit, my lord.
So the circuit bench is since Monday.
Since Monday, and Monday is 3rd, my lord. My interim order would expire on 28th, my lord. If your lordship would kindly accommodate, my lord.
Why? Monday is the next day.
No, but since the
interim that day, Saturday and Sunday is there.
Yes,
so
Saturday.
You can mention it on Monday before the appropriate.
No, my lord. On Monday, since my lord, the application, my lord, the interim order would expire. So mentioning will not be allowed. I'll have to take out an application. If I take out an application, my lord, that will take further time. In the meantime, license may be issued. That is the reason, my lord. But you will kindly show some mercy, my lord. Kindly, my lord. At least, my lord, in this matter, my lord. I will never come back, my lord, with these matters again, my lord. In fact, this was a, my lord, miscalculation of dates, my lord. My learned junior was perhaps under the impression that the interim order are till 20th
Okay, tomorrow to be mentioned.
Obliged, my lord. Deeply obliged. Deeply obliged.
File is there. Then how can it pass? The file is not there.
These are all extension, my lord. I will hand over the hard copies, my lord. All extension matters.
No. Order has to be passed upon the order file paper.
Well,
is not with me.
Well, I understand, my lord. Let this be to be mentioned, my lord. If the file does not come, my lord, we'll try and arrange.
File can come.
Digital, my lord, electronically, because everything is on, my lord. These are state matters. But we will take steps. If my lord, the file are not here, my lord, lordship will not pass any order. If the file is not here,
will reach here. The papers is required. That is the order book.
Yes, my lord. What happens is, my lord, they transfer the file through email, and my lord, here the registrar takes out the printout and it will be placed before. Other matters, my lord.
Let the matter appear under heading to be mentioned tomorrow.
Tomorrow. Well, we will take steps. We will take steps. Obliged, my lord. Deeply obliged. Deeply obliged, my lord.
Today.
Deeply obliged.
Ajay Kumar Mukherjee. Ajay Kumar Mukherjee key determination, civil determination. Criminal revision. Nine matters.
Eight matters.
No, so many matters I cannot be taken.
All same, my lord. All interim orders will expire.
I understand.
All same matters, my lord. Same matters.
Not so matters. Only one matter.
That will not help the cause, my lord. Since your lord, my lord, similar order would be passed in respect of the other 7 also, my lord. Kindly, lordship will kindly, my lord, kindly accommodate, my lord.
My determination since November, I have not gone through such a situation.
But even in my life, I have not gone through such a situation, my lord. It is only under, as I said, my lord, under compelling circumstances, my lord. Because he was under the impression that the orders are till 20th of March.
28th of March, then the next day is the Monday, 3rd March.
No. My learned junior was under the impression.
28th of February, and the next day is the 3rd March.
My lord, 3rd March.
What is your difficulty?
My lord, by then the interim order would expire.
Then you 3rd March file an application. What is the difficulty?
No, if I file an application, my lord, it will take some time to be listed, my lord. In the meantime, if the license is issued, my lord,
then you mention on 3rd that I have to file one application. So an interim order may be passed. Why before this?
Well, the court will ask me to file an application, my lord, and that will take time. The writ petition will become infructuous. Let me try, my lord. Let me try till tomorrow. Let me try.
No, that situation cannot be tackled. by that way. I cannot pass any order without the papers,
If
without the
the
order
papers do
book.
not come, if the papers do not come, Lordship will not pass any order.
রাখুন।
Obliged, deep blue.
Call the list.
That I appear for the petition.
For the college authority, Lordship.
Avalon Shiksha Niketan.
Lordship.
I am reading out the only operative portion of this order. Under the above facts and circumstances, after careful perusal of the impugned order passed by the respondent number 6, it appears to me that the order is not at all perverse, unreasonable, arbitrary. Thus, this court find no material to interfere with the impugned order. Consequently, writ petition fails and disposed of as devoid of merit.
Lordship.
I am for the petition order.
For the respondent, my lord.
Affidavit of service.
Before my learned friend proceeds, my lord,
Yes,
two submissions, my lord, which perhaps will benefit your lordship, perhaps, my lord. As regards to the contention which I had read that this writ petition ought to have been filed before the residuary bench, my lord, but identical tender matters were being filed. And fortunately, we both were there in the matters. Heard extensively by the bench, but otherwise also lordship can hear out the matter. That is first part. Second part is, if my learned friend presses for an interim order, my lord, there is no scope for an interim order that I will indicate, my lord. If your lordship wants to hear me now, and that will cut short the matter perhaps, otherwise my learned friend will place the facts in detail and everything will go.
Petitioner, I shall make submission whether there is any scope for interim order. What will consider? Before
Now,
placing my case,
two things I will place, my lord. My learned friend's client was being rejected in the bid, and thereafter fresh letter of acceptance has been issued in favor of third parties, in favor of 3 third parties. Contract has also likely to be executed. Third party rights have been created, my lord, and that has been done even before filing of the writ petition. So in any event, the writ petition is become infructuous. Okay. Well, I will
okay,
play.
you proceed.
Very well.
my lord, a tender has been floated by the Hindustan Petroleum Corporation Limited
Yes,
for supplying bulk petroleum product. If you lordship kindly turn to page 26 of my writ petition. But I am a serial cast candidate that will appear from page 26.
yes,
Serial cast candidate, and I am a micro, small and medium enterprise that will appear from page 27. Some quotas have been reserved for serial cast and micro, small, medium enterprise that I have annexed. There is no dispute about the same also, page 27. Middle
Micro,
portion, name of
small-
the units, North Code Transport, top miler,
micro, small, medium enterprise.
enterprise, MSE.
Yes,
And I am also serial cast. Kindly come to page 29. This is the tender notice notified on 14th of August 2024 by the Hindustan Petroleum Corporation Limited. Kindly see the middle portion, second line, bulk transportation white oil from ex-Haldia terminal. Have you also got my note? Page 29.
page
Top.
29.
Middle portion,
Tender of
second,
transportation of bulk POL.
yes,
Product.
bulk white oil ex-Haldia terminal from the tender notice issued on 14th of August 2024. Then kindly turn to my note, straightway page 119. Now, this is my online application. Kindly see, I have submitted my application under MSc SC category, second
Yes,
table. Microsoft Engineering, steel cast. And memo number, tender number also given. Then kindly turn the page my lord, 120. This is 30th December 2024. I have been selected on the basis of the rate quoted by me. First line, please find enclosed scan copy of the signed letter of acceptance, LOA. Please acknowledge receipt. Then, my lord, this is very important. What is the instruction upon me? Kindly carry out the contractual agreement immediately and submit the security deposit so that EMD can be refunded to you. My lord, kindly take note of only two instructions. Contractual agreement, carry out the contractual agreement immediately and submit the security deposit. Next line, the delay in completing the above activities will have impact on EMD auto refund process, as the EMD auto refund process windows is valid for a very short duration as per RBI guidelines. Therefore, please complete the contract agreement process and security deposit submission immediately. So
Yes.
instruction upon me to deposit the security money, that's the only instruction upon me. Kindly turn the page, my lord, next page. Provisional letter of acceptance. Previous one was the communication letter, covering letter. Now it is the provisional letter of acceptance, LOA. Subject, this is 23rd of December. Award of contract transportation of bulk petroleum products, Messrs. HSD branded fuels by road ex-Haldia terminal for period of 5 years with effect from 1st January 2025 to 31st December 2029. We refer to your offer received against our subject and please to issue the provisional letter of acceptance under general category. Kindly take note of. Admitted position, I am a civil caste MSc candidate, but wrongly it has been recorded that I am general category. I have been selected also under the same category. Is applied by you for transportation of bulk petroleum product and standard fuels to answer terminal at the following rates. Kindly see, my lord, the box. Left hand side, truck capacity, tank truck capacity, TT capacity. First one is 12 and 18 KL, from 12 KL to 18 KL. Owned. My lord, I have produced in terms of the condition of the tender notice, 12 KL to 8 KL tank trucks and 18 KL to 25, 6 tank trucks. Total in 7 TTs. Have a look what is in the table. So for left hand side, 12 to 18 KL, then kindly turn to the last line of the first column, 1.
Yes.
Then 18 to 25 KL, 6. Total 7. I offered total TTs 7.
Yes.
Then rates have been quoted. Then kindly second paragraph of the bottom. You are requested to come forward immediately for completing the following formula. Kindly submit performance security of rupees 8 lakhs, rupees 50,000. So far I am concerned, 50,000 is concerned because since I am a civil caste candidate, in the form of demand draft drawn on any scheduled bank, an operative bank in favor of Messrs. Hindustan Petroleum Corporation Limited, as specified by HPCL in the form of bank guarantee strictly in society pro forma, provided in the tender document, valid up to 6 months beyond the expiry of the dismissal. Please bring the original documents of MSc certificate and caste certificate offered in the tender for your verification. Please bring the original documents owned attached tank trucks offered in the tender as given below for your verification, which book, RC book, calibration certificate, explosive license, fitness certificate, and photocopies of the same documents. Then details of the TTs have been recorded with their capacity. Then see paragraph 8. Please note that as per general terms and condition, execution of agreement, placement of TTs less than number of so work order shall not be permitted. You are required to complete the above formalities within 15 days of the date of issuance of this letter of assurance and place the tank trucks for induction immediately thereafter. Kindly take note of induction thereafter. First agreement, then induction. Now kindly turn to page 124. This is the communication left hand side top, 13 January 2025. Kindly come, dear transporter, letter of acceptance copy is received by you on 30th December 2024. Via email per LOA once of physical verification of it have been done. Kindly take note of. LOA copy is received by you on 30th December via email. As per the letter of acceptance, physical verification of TTs have been done at Haldia Terminal. I have placed all that 7 TTs before them and they have done the physical verification. Now, following activities are pending as per letter of assurance, terms and conditions. Reference level so-and-so, BGBT so-and-so, then my lord, kindly submit performance security rupees 8 lakh or 50,000 in the form of so-and-so, drawn in favor of so-and-so, then 2, bottom portion. Reference level so-and-so, verification of original MSc certificate and caste certificate. I have placed all 7 vehicles, then I have been directed to deposit the security money and verification of original MSc certificate and caste certificate. There is no dispute about the same. Next page is the my lord, security deposit document in favor of Hindustan Petroleum Corporation. They are not disputing the same. Kindly turn to page 126. This is a communication left-hand side top, 21st of January 2025. Reminder, agreement and TT induction as per LOA issued dated so-and-so. This is the issue involved in this matter. I have submitted all documents. I have placed all the vehicles. I have deposited the security money. Then agreement shall be executed. Then question of induction of the vehicles will come later on. But in this letter, before execution of the agreement, I have been instructed to submit the induction for all the vehicles. Once again, I am reading my alert. Reminder, agreement and TT induction as per LOA issued dated so-and-so. In the LOA, I have shown to your lordship, there is no instruction that I have to place the vehicle for induction. What is the induction? I shall come later on, my lord. That is key and other things are there. Kindly take note of. This is the first time, not in the LOA, there is no such instruction. LOA says deposit of security money and place the vehicles. Subsequently, I have been directed to submit your certificate, MSc and Silica certificate. That all I have done. Now, without executing the agreement, I have directed to place all the vehicles for induction. What is the induction? I shall come later on. Placement of TT safety finding, checking and induction. Kindly take note. 1, placement of TT of safety fitting, checks and induction. Please do the above activity as per LOA terms and conditions within the stipulated time. Now, kindly turn the page, next page. Another communication dated 28th of January 2025. Sir, refer telling so-and-so, you have placed all 7 TTs for physical verification within a week from LOA issue. You have deposited security bank guarantee. Have you lordship got, my lord? So I have done. I have placed the vehicles and also the security deposit. However, you have yet to submit NOC. Then, my lord, another thing. Because why this NOC is required? My present 5 vehicles out of 7, I have engaged in IOCL authority. There is a provision. I can offer TTs engaged in other company, but I have to submit NOC after execution of the agreement. I have done so. I have requested LOI, please give me NOC. They said me that unless an agreement is executed with you, PPCL, IOCL cannot release these vehicles. I shall show you that later also. You are once again advised to comply the above as per LOA tender notice. LOA tender notice never suggests that I have to submit NOC and place the vehicles for induction prior to execution of the agreement. Prior to execution of the agreement, only 2 roles. First, I have to deposit the security money.
Yes.
Silica certificate, MSc certificate, and placing the vehicles to show with all documents that I am the owner of the vehicle. That all these 3 things I have done, but without executing agreement, 2 instruction, further instruction has been given to me for induction of the vehicles and NOC from the other oil company. Now I have kindly come to the next page. This is a communication of 29th of January 2025, middle portion bottom. I have been addressed Gopal Noskor. Respected sir.
Page 128.
Well, this is my reply.
Page 128.
128.
Yes.
I have written a letter. Respected sir, I like to inform you that I have already submitted application in India for NOC and replacement of the vehicle number 5 vehicles, 5 TTs. I have signed the agreement and submitted to you. It's pending from your side. But an agreement copy has been handed over to me. I have endorsed my signature, handed over to the Hindustan Oil Corporation Limited for their signing. In tender terms and condition, it's saying, if I would not able to submit security deposit, then my LOI would be liable to be cancelled. Regarding NOC, if I will deny or not able to submit at the time of induction, then only my LOI will be liable to be cancelled. But I am saving you that I have already applied for NOC, and as soon I will receive, I will submit it to you. I have received 7 TTs in LOI request also. Then next line, I am a 66-year-old man and recently I have been eye operation. Then last line, there is no time bound is given for induction of TTs and to provide NOC. Neither in the agreement, nor in the tender documents, nor in the LOI, there is any condition that before execution of the agreement, I have to submit my lot, all TTs for induction and provide NOC from the oil company. I shall show to your lordship. Now, my lord, the next page, my LOI has been cancelled. That is, my lord, page 129, 10th of February 2025. Immediately, I asked before this honorable court, my learned friend today is saying that they have already executed agreement or LOI has been issued. On the last occasion, when my learned friend prayed for adjournment, he said nothing has been happened. Kindly take my lord, page 129. Please find attached LOA cancellation letter, then Nama so and so, acknowledged so and so. Then my lord, middle portion, sir, refer trailing so and so. You have placed all 7 TTs for physical verification within a week. You have deposited SD so and so. Again, they have reiterated. Now the cancellation letter at page 130. This is the communication of 7th February, which I have received on 10th of February, page 129, covering letter. Subject cancellation of provisional letter of acceptance, reference number so and so. We refer to the provisional letter of acceptance issued to you dated 30th December 2024 under tender number so and so for the transportation of bulk petroleum products and branded fuels by road external terminal for a period of 5 years. As per the terms and conditions of the LOA tender, you are required to complete the following formalities: verification and submission of original documents that I have done, submission of SD and execution of agreement. I have kindly see, my lord, that this is their statement. That second paragraph says submission of security deposit and execution of agreement.
SD means
Security deposit
security deposit.
and execution of agreement. Later comes on, kindly see, induction and placement of tank. In this case, my lord, I have done everything without executing agreement. They are cancelled my LOI on the ground that induction and placement of tank trucks as per the schedule. This is come later on after execution agreement. Why I shall place before your lordship? Because if I obtain NOC from the other oil company and ultimately you reject my application, I cannot continue my business with that oil company. The agreement, tender terms and conditions, everything suggests I have to deposit the security money. I have to place all the vehicles, whether I owned or not, with all documents in connection with the vehicles. I have to deposit security. I have to place the vehicles and also all certificates, that is Silka certificate and other certificates. Then execution of agreement, then induction. What is induction? I shall come before your lordship later on. It has been observed to you that so-and-so, mail dated so-and-so, as you have mentioned, last but one paragraph, as you have mentioned in tender document that TTs number so-and-so, so-and-so, so-and-so are currently plying with OMC, Oil Marketing Company, IOC Holder. Also, IOC Holder confirmed the email that these TTs are plying with them. But they wrote a letter to the IOC requesting them whether these number of 5 TTs are plying with them or not. IOC confirmed the same also. That yes, 5 TTs of the repetitioners are plying in IOCL and he has applied for LOC also. But according to the terms and condition, IOCL cannot hand over the NOC unless an agreement is executed with the other oil company. Now kindly the next line. Also, IOC holder confirmed the email that these TTs are plying with them. You are unable to submit NOCs within stipulated time as per LOA tender terms and condition. Consequence agreement signed for done so within 30 days. As per terms and condition and declaration of given by you, in tender document, NOC of the TTS transport will be submitted before induction. Kindly take note, my lord. Once again, NOC will be submitted before induction, but not before agreement. This is their terms. Last line says, NOC of the vehicles plying in other oil company shall be submitted prior to induction of the vehicles, not before, not prior to the agreement, execution of agreement. Just one line, my lord, from the LOI. Kindly see, my lord. Page 120. Once again, my lord. Whether there is any condition or not. Kindly come to my lord, page 120. And 121 is the LOA. Kindly come 121, provisional letter of acceptance. Add, I have already placed, once again I am placing for my satisfaction. Add of contract transportation of bulk petroleum product so and so for the period so and so. We refer to your receipt agent so and so and accept please to issue the provisional letter of acceptance under general category. Kindly take note, general category. Applied by you for transportation of bulk petroleum product so and so. Trunk numbers have been given. Then one, bottom portion. Kindly submit performance security of rupees so and so. Then next one, no instruction upon me for placement of vehicles for induction. And two, please bring the original documents, MSc certificate and caste certificate. Please bring the original documents owned by attached trucks. And 8, please note that as per general terms and conditions execution of agreement, placement of it is less than number so and so, you are required to complete the above formalities. What is the formalities? Placement of vehicle, certificate of MSc, schedule caste, and security deposit. In every letter, they are saying, as per terms and condition of LOA, you have to submit all the vehicles for induction and you have to also submit the NOC. Now, your lordship, kindly come to the terms and condition of my agreement. Kindly turn to page 40. It starts from page 40. Neither tender terms and condition nor LOA ever suggest that I have to place all TTs for induction. I have to submit the NOC from other oil company prior to agreement. Kindly turn to page 40. These are the agreement. Kindly turn to page 43. The terms and condition. Page 43 says, Roman 3, after before table, estimated trunk truck requirement from transporter. Trunk trucks requirement description. 12 KL to 18 KL requirement is 35.
Yes.
18 to 24 KL 20 requirement. Now kindly come to the last table, bottom portion. Reservation of purchase preference category wise tank truck requirement. SC quota as per requirement, 15% of total requirement, 12 to 18, 5, and 18 to 24, 3. Then kindly turn the page. It has been brought forward from the previous selection process since it was not filled in. SC quota, SC carry forward from revised under so and so, previous tender. Total SC quota 17. Have you also got pilot?
Yes.
So far 12 to 18 kg is concerned and 9 so far pilot 18 to 24 kg is concerned. That will appear from the last table of the page 43. So 12 to 18 requirement 17 and 18 to 24 9. Reserved for serial cast after carry forward from the previous selection process.
Yes.
Now kindly turn to page 64. Middle portion miscellaneous page 64. Kindly turn the middle portion miscellaneous.
64.
Yes. A 45A. HPCL reserve the right to accept any tender in whole or in part or reject any or all tenders without assigning any reason. In this so and so. So what I have submitted before your lordship, if I withdraw all my vehicles by obtaining NOC from other oil company and place the same before agreement, they may cancel my LOI and also cannot also are entitled to not to execute the agreement. Now, your lordship, kindly come to page 68. Qualification criteria. need not go through the top portion. Kindly come to serial number 3. For SCST transporter, SCST transporter shall be allowed to participate with a minimum 2 TTs, out of which one shall be owned by him. In this case, my lord, I am owned all 7 TTs. In case TTs offered are more than 2, minimum 60% of the total TTs shall be owned by SCST candidate. Participate with booking slip. Kindly take note of booking slip. However, booking slip TT will not be considered for arriving at sub-ranking. Tank trucks under booking slip. Bidders who wish to offer tank trucks of any approved capacity which are not in their possession as on the due date, extended due date, or tender can also participate along with a booking slip and an affidavit in the prescribed format that they will be have to physical possession of the vehicle, along with all statutory license within 90 days from the date of issuance of LOA. Kindly take note of. Even person concerned having not owned any vehicle, only booked the same, they will give 90 days time to them. So far I am concerned, within 15 days I have done everything. Now next line. License within 90 days from the date of issue of LOA. Booking slip in the name of the applicant is required to be submitted along with the affidavit. Tank trucks offered against affidavit shall be physically positioned at that location within 90 days of the date of issuance of LOA. Work order failing which EMD submitted so and so shall be terminated. Then kindly turn my lord. Page 112. State rate. This is general terms and condition of the tender notice, tender document. Page 112. Kindly tap serial number 6.
Yes.
For tank trucks under operation with any other oil company and unconditional no objection certificate is to be obtained from the concerned oil company for placing the same fully in the service of HPCL against the tender. NOC to be submitted at a time of induction of the tank truck. It never suggests neither the agreement nor by the tender condition nor in the LOA that I have to submit the NOC prior to execution of the agreement.
At the time of induction of the
Induction.
of the TT.
What is the induction? I shall show to your lordship now. Kindly come to page 114.
114.
Last line, last but one, before paragraph 17, LOA. Successful bidders will be issued letter of acceptance. Date of HPCL email sent along with LOA. Copy of the bidders will be considered. As issue date of LOA, bidders will have to comply with all formalities as specified in the LOA, failing which the LOA may be cancelled, AMD forfeited, and action taken by HPCL holiday listing guidelines. The guidelines for holiday listing so and so, security deposit. Then next page, successful tenderers will be required to furnish performance security, performance security within 15 days of the issuance of LOA or so and so. Then straightway kindly come to Roman 5. Not necessary, kindly come to the next page. Execution of agreement, page 116, middle portion 19A. I have shown to your lordship, straightway kindly come to the rejection order at page 131. 1 second, page 131. This provision has been relied on by them. Page 131, second paragraph. In view of the above, as per general terms and condition 19A of tender number so and so, we regret to inform you that the LOA issued to you stands cancelled within immediate effect also. Your submitted EMD and SO shall be forfeited. So, but they have exercised power by cancelling my LOA. Exercising power under clause 19A. What 19A says? Kindly turn to page 116. These are the only provision they have relied upon in my cancellation letter. 19A I am reading, successful tenderers will be required before undertaking the contract to execute the agreement. Kindly take note of. Successful tenderers will be required before undertaking the contract to execute the physical placement of the tank truck I have done at the location within 30 days from the issue of LOA. Work order HPCL may show additional time up to 15 days for execution of the agreement in case of failure the HPCL so and so. So, my lord, placement of vehicle first, then agreement. Then kindly turn to my lord, serial number FG. Specimen transport agreement is enclosed along with the tender document. tenderers are advised to carefully go through the terms and conditions of the contract agreement before submitting their tender. That copy of the agreement, I endorse my signature, I handed over them with all documents, security deposit, placement of vehicles, all documents in connection with the vehicle, my ownership, registration certificate, everything, as also as SC certificate original and the MSC certificate original. It says, well, the agreement shall be executed immediately thereafter. Then, my lord, I is most important, GHI. Failure to execute the agreement, kindly take note of, or furnish required security deposit within 15 days time, or physical placement of trucks that I have done, trucks at the location within 30 days, they may render the tenderer liable for action in the with tender TNC agreement, transport discipline guideline, and so and so. Everything I have done. Then, my lord, kindly come to induction. Induction. But kindly come to two paragraph of my repetition. Para 10, page 9. Para 10, page 9. Just 2-3 paragraph I will read.
Yes.
Your petitioner states that as per direction contained in the email dated 30th January 2025, that is the, my lord, LOA, your petitioner on 21st of January 2025 submitted the security deposit in form of demand draft and also original documents of MSME certificate and the caste certificate. Your petitioner also states that on the very same day, on 21st January 2025, your petitioner also submitted the signed copy of the agreement before the HPCL authority, HPCL Haldia terminal for execution of the said agreement. Paragraph 11. Your petitioner states that after submission of the security deposit and copy of agreement and original document of MSME certificate and caste certificate, HPCL authority, without taking any steps to execute the agreement, manager operation Haldia terminal 5 mail dated also directed to your petitioner to place the offer duties for induction. In this regard, it is pertinent to mention here that agreement will be executed by and between the oil company and the transporter before placement of duties for induction. 12. Your petitioner states that 5 duties out of 7 duties of your petitioner have been engaged with IOCL, and your petitioner has already approached IOCL for obtaining NOC of those 5 duties. However, stance of the IOCL is unless petitioner can place the agreement with HPCL in regard to those 5 duties as per industry guideline being followed by all oil companies, they cannot issue NOCs in favor of the petitioner. IOCL stance is very clear. Unless you execute an agreement with HPCL, we cannot release your vehicle. And question of NOC does only arise after production of NOC, after production of agreement with the other oil company. That's the stance of all oil companies. This oil industry guideline is being followed by all. This is written by the Ministry of Petroleum and Natural Gas. Now kindly come to paragraph 30. EFTA states that since the IOCL authority following the tender document of HPCL and industry guideline followed by all 3 oil companies told your petitioner that immediately production of copy of the agreement to be executed by and between the petitioner and the HPCL authority in respect of those 5 engaged duties, they will issue NOC. Your petitioner met the manager operational HPCL and clarified the situation with the request for immediate execution of agreement so that your petitioner can place NOCs of the said 5 duties. It is pertinent to mention here that with all other selected bidders of the subject tender, including SC category selection bidders, agreement HPCL has executed agreement without insisting for placement of offered duties for induction. In the same tenders, other selected candidate agreement has been executed. Till today, they have not produced their vehicles for induction. Now, my lord, the next bit is also pertinent to mention here that with the SC selected candidates who have applied with disclosing only booking slip of the TTs have also executed agreement by the HPCL without insisting for production of vehicle. Persons who have applied for with booking slip, agreement has also been executed with them. They not even become owner of those TTs. Paragraph 14. In the aforesaid backdrop, while your petitioner was waiting for a call from HPCL authority for execution of agreement, so that petitioner can submit the NOC to be issued by the IOCL and placement of all 7 NOC of TTC in induction. Your petitioner with his utter shock and surprise received the induction. My lord, kindly come to paragraph 14. Paragraph 15 first. At page 11, your petitioner states that since the tender document dated 14th August 2024 never prescribe either placement of NOC or placement of PTs prior to execution of agreement. Immediately thereafter on so-and-so, your petitioner made a reply through the so-and-so. That reply have placed before lordship need not. Kindly turn to page, paragraph, my lord, next page. What is the induction? Page 12, paragraph 17. Your petitioner states that induction of TTs meant for change of color of the TTs. Well, this is the oil companies, prescription is separate. Now, presently, 5 TTs have been colored as per prescription of the IOCL. But if they don't execute the agreement ultimately with me, before that, I cannot change the color. It is lying before the IOCL authority. These are the practical difficulties. Now, next, as per specification of the IPCL locking system, this is also separated by 3 oil companies. Different procedure has been followed by 3 oil companies in respect of color, locking system, as per specification of HPCL, third-party inspection and certificate and branding as per HPCL. These are all technical terms being followed by 3 oil companies according to their own prescription. My vehicles is flying with the IOCL. Color, locking, everything is different. According to them, before execution of agreement, you have to change everything. And only then we shall execute the agreement. There is a provision, they cannot execute the agreement with me. Then what will be happen? I shall obtain the NOC from them. IOCL stance is very clear. Bring the agreement, we shall within 2 days issue the NOC. We shall release all the vehicles. I have also written the same at page 13. Your petitioner states that as per condition of LOI, HPCL reserve the right to cancel LOI without signing. Accordingly, unless the agreement is executed by the HPCL, lifting the enrolled TTs from IOCL by obtaining NOC and induction of TTs as per specification is absurd in all respect. Then paragraph 19 is all very important. Your petitioner states that in the said tender, namely candidates, namely Radharani Roadways, Kamala Kanti Logistics, Momita Enterprise, Ghosh Oil Carrier, Prince Transport, Khan, Bulk Transport, Raja Transport, etc. have been selected as successful candidate bidders in the respective categories. And before induction of their TTs, the respective agents have been executed, agreements have been executed and between oil company and the respective transporter candidates. However, in case of your petitioner, before execution of agreement, your petitioner has been directed to place the TTs for induction and also directed to submit NOC prior to execution of agreement and subsequent thereto the LOA dated transfer has been cancelled by the IOCL authority, which is contrary to the tender documents and clearly violates petitioner's right protected transfer. I have also taken the other grounds. I am not placing this. Today, my lord, if your lordship dispose of the matter, I have nothing to say. There are 20. My lord, one paragraph my learned junior is insisting. Paragraph 20.
Paragraph
20, page 14.
yes.
Your petitioner states that till today, no induction of any TTs of any other selected candidates has been conducted, taken place by the HPCL authority under the same tender, with whom agreements have been executed. However, in case of petitioner, beyond the terms and conditions of tender notice and LOA, a petitioner has been insisted for production of NOC and induction of TTs prior to execution of the agreement, and for non-compliance of such absurd proposal beyond the scope of power, reserved the HPCL of the petitioner has been cancelled by the oil company. A petitioner states that before cancellation, so and so, so and so, then your lordship, if your lordship dispose of the matter, I have nothing to say, but otherwise, my lord, your lordship may pass the interim order as I have paid for at page 23. H and I, an order to issue restraining the respondent from giving any effect or further effect to the order of cancellation provisional LOA issued in favor of the petitioner issued by so-and-so, an order to issue restraining the respondent from issuing any provisional LOA and execute agreement subsequent thereto in favor of any other candidate under this category pursuant to the tender notice so-and-so, an order to issue direction to execute the transfer agreement. But these are my case. In respect of all tenderers, agreement has been executed. Till today, none of those selected candidates produced their vehicle for induction. So far I am concerned, everything I have done as per their LOA condition, as per the tender documents, placement of all 7 vehicles with all their documents, registration certificate in my name. I have deposited the security money. I have a serial cast candidate. I have also placed all the certificates in a serial cast, NSC, everything. money has been deposited, vehicle has been placed, document has also been submitted. Only so far NOC is concerned, it is a binding responsibility of the IOCL. Unless we produce the agreement, they cannot release it. The industry discipline guideline says. These are my case.
So, in the tender,
My lord.
can you use the TTs used by the other oil
Yes,
company?
that is the provision I have shown to your lordship. Once again, I am showing. Page 112,
112.
my lord. 112,
General
Yeah,
terms
that-
and conditions.
yes. Clause 6. For tank trucks under operation with any other oil company, an unconditional NOC is to be obtained from the concerned oil company for placement the same fully in the service of HPC against the tender. NOC to be submitted at the time of induction of tank trucks, not before execution of the agreement. It is admitted position, I can. My used vehicle in other oil company offered for other agreement. But I have to submit an agreement, NOC at the time of induction of TTs. Induction means change of color. Induction means change of locking system. Induction means third party inspection according to the prescription of the respective oil companies. At present, all those 5 TTs, so far other 2 TTs is concerned, I am ready. I can produce at any time. But so far engaged TTs of IOCL, they cannot issue the NOC. Because there is an agreement also for some period. Before that period, I am playing them, please hear the word. They are ready and willing. They have confirmed to the HPCL authority also that these 5 TTs are engaged in our office. I have shown to your lordship. That is their communication to me. Yes, we have taken information also. There is no false statement, nothing.
Okay.
My lord, this is my submission.
Yes.
Just a fine.
Observation level. Well, the first document, my lord, I wish to rely on is at page 130. But if your lordship kindly comes first at the at page 121, the LOA. This is the letter of award granted in favor of the petitioner, my lord. If I may place the relevant portions, my lord.
Yes.
Subject, award of contract, transportation of bulk POL products of MSHD and branded fuels by road ex Haldia terminal for the period 5 years with effect from such and so. Well, before placing the document, well, if I may indicate a few things, madam. But this risk petition suffers from gross suppression of valuable material facts. But there are truncated emails which are being annexed purposefully and not the entire set of correspondences that have exchanged between the respondent and the petitioner. But the tender which has been annexed, my lord, that also is in truncated form. Because the other provisions of the tender condition, which perhaps is going to go against them, my lord, that has not been annexed. Though I have got a copy of the entire tender condition, my lord, I'll file it, place it before the lordship when I place it, my lord. Third, my lord, the letter of acceptance was issued on 23rd of December 2024.
Letter of
Acceptance, LOA. The date of LOA. Well, at
120.
121.
120.
121.
23rd of December.
23rd of December. Now, if your lordship comes to the next page, please note, clause 8. Please note that as per GC general terms and condition, execution of contract, execution of agreement, placement of tank trucks less than number mentioned in LOA, work order shall not be permitted.
Yes.
But I will produce a copy of an email which clearly will demonstrate a fact that, my lord, out of the 7 tank trucks that was been offered, only 2 were available with them. Other 5 were plying with IOCL. And the submission today which has been made that if we give them an agreement, IOCL will release that. That's a completely imaginary submission, has no basis to it, and that's just not the practice. Reason why I say so, but the contracts are being done with a particular period, for a particular period. Suppose I take this contract.
No, general condition says you can use the TTs which was employed in other oil companies.
But that is, there is no clause as such.
Yes,
I-
he has shown that there is a clause.
That's a NOC clause, my lord. But
Yes,
we-
NOC.
NOC clause that they are liable to produce, my lord, which they are unable to. But they did not even apply for the NOC as late as February. IOCL has disclosed all those facts. I will place the documents one after the another. But if your lordship comes to clause 4, you are required to complete the above formalities within 15 days from the date of this LOA and place the tank trucks for induction immediately. My lord, 15 days, my lord, from LOA. Kindly seize, my lord. 23rd of December 2024. Within 15 days, my lord. Not been done because the tank trucks were not available with them. Now the next clause is clause 5 is the period of validity. Now if I take your lordship directly to the cancellation of the LOA, which is at page 130.
130.
Please, we refer to the provisional letter of acceptance issued to you dated 30/12/2024. That was perhaps been mailed after 7 days. So it will be calculated from 30th December under tender number such and such for such and such for a period of such and such. As per tender conditions outlined LOA tender, you are required to complete the following formalities. Well, these have been placed by my learned friend. Now, if your lordship comes to the next paragraph, it has been observed that you have not completed the required formalities within stipulated time frame despite multiple reminders. But these are all 4 documents which has been suppressed by my learned friend. And reasons are quite obvious. As you have mentioned in tender document that TT number such and such, four TTs are currently applying with OMC, IOCL, Holdia. Also, IOC Holdia has confirmed in email that these TTs are applying with them. You are unable to submit NOC within stipulated time as per LOA tender terms and conditions. Consequence agreement not done within 30 days from LOA received date. As per tender conditions, the declaration given by you in tender documents, NOC of TTs will be submitted before induction. Right? They have given undertaking, which are also I am there. I'll produce those undertakings. They have given an undertaking to the effect that if we cannot produce the NOC, but our LOA will stand cancelled. Non-compliance, if I take your lordship to the next page, at page 131. Non-compliance with the LOA terms has resulted in our inability to proceed further with the contract finalization. In view of the above, as per general tender terms and condition clause 19A of tender number such and such, we regret to inform you that the LOA issued to you stands cancelled with immediate effect. Also, your submitted EMD and SD will stand forfeited. Please note that this decision is in line with terms and conditions of the tender and applicable guidelines, including transportation discipline guidelines such and such. But this letter was being sent to them on 7th of February 2025. Very well, on 10th of February, page 129, email was being sent on 10th of February.
Yes.
If your lordship kindly comes to page 25 once.
Page 25.
25. But they have filed the writ petition, whereas we cannot indicate on 18th of February 2025. But if I may hand over this copies, mother. But on 14th of February 2025, LOA has already been issued in favor of third parties. even before the filing of the writ petition. Otherwise has become infructuous. My learned friend, if at all he has agreed with his termination, has other remedies in accordance with law. He could have very well argued that I have immediately filed a writ petition, and pending writ petition, my lord, this has been done. That is not the case. 7th, it was been cancelled. 14th, 3 letter of award has been issued in favor of 3 candidates. But there are 3 parties now. Security deposit, all formalities are complete. So in any event, this writ petition does not survive. Because at this juncture, my lord, but in view of the fact that the LOA has been issued, third party rights already been created, my lord, but this in writ petition automatically does not serve.
No, what is the conditions? For, if the TTs are under operation of other oil companies, what
But
is
that I will go
procedure?
into the merits, my lord. That is purely on merits, my lord. If your lordship wants to hear out, my lord, the first point that I'm arguing today is the maintainability of the writ petition. My learned friend has to cross the first hurdle. Then your lordship will consider the merits.
(121) is the
LOA.
LOI.
They can cancel it, my lord, without any assigning any reason. No agreement has been executed. Even if I accept the submission of my learned friend, that LOA has been issued to other person, I don't know whether they are single cast or not, or same category or not. Some documents without giving me copy, placing before your lordship, saying writ petition has become infructuous since
We are
LOA
at
has
the
been
ad interim stage, my lord. We are at an
SOA, LOA can be withdrawn part anytime.
My lord, that lordship
It
is
is the
waiting on affidavit.
Prerogative of your prerogative of your court, this court, that your lordship may issue an order whether LOA is issued or not. It is immaterial, because LOA can be cancelled, withdrawn at any time without assigning any reason. No agreement has been executed. My learned friend is not saying that agreement has been executed. Unless agreement has been executed, it can be withdrawn at any time. Even I am assuming that agreement LOA has been issued. I am purely calling in a SC category. First communication, I am general category. You have treated me as general category candidate. Your lordship passed order,
Case of general category, SC category, the
reservation, only
default
reservation.
value of the
Security deposit and the reservation.
8 lakhs and 50,000.
Fine.
And the reservations.
And reserved candidate can apply by offering TTs with due slip. And in that case, they are getting 90 days time. So far I am concerned, I own the vehicle, I place the same, they satisfied and intimated me, yes, you have placed all your vehicle. Yes, you have deposited the entire money. Yes, you have produced the certificate, Silka certificate and NSC certificate. That is their case. All the documents of my vehicle have been produced along with the physical verification of the vehicles. By taking from IOCL, I have placed all the vehicles. That is their communication.
So your submission is that agreement has to be
Execute
entered into first.
prior to mandatory induction and prior to. Well, so far these candidates are concerned whether there is any instruction for production of induction. There is no such instruction. I believe so. Kindly go through it. Definitely there is no instruction for induction of vehicles. That is not the terms and condition. 19(1) only suggests
But
Production of
I
vehicle.
will place the tender condition if your lordship
Tender
intends.
condition I have shown to your lordship.
Here,
Only clause you have relied on, 19A. It does not refer induction or NOC.
after affidavits, if your lordship want to.
Why
hear,
affidavit?
Then has to be heard. Then I will place the merits, my lord.
Place
Today
the case on merit.
we are at a stage, my lord, where the writ petition does not survive at all.
My lord, kindly see two documents, my lord. Once again, I am saying what my learned friend has submitted. But kindly come to page 121. LOA. My learned friend should submit on authority. Page 121 is the
120 is the
121, the LOA.
LOA.
Next page. Kindly come to serial number 4. You are required 4 at page 122. You are required to complete the above formalities within 15 days, 90 days in case of booking slip of the date of so and so. This letter has been issued, kindly see 3rd December 2024. Instruction is top 122. MSc certificate, security report is at page 121 bottom. Letter issued on 23rd. When I have submitted, kindly see, kindly come to page 125. 21st of January 2025. And intimation is page 124. Kindly come to page 124. When they have intimated me for production. This is 13 January 2025. I have been instructed. Kindly come to serial number 1, middle portion. Kindly submit performance security of rupees so and so and ribbon draft so and so and 2 verification of original MSc certificate.
I believe my
My
learned friend has concluded it, my lord.
No, I am giving the
did not-
reply. You have given the
I have not
submission.
concluded with my
It's
submission.
not within
How
7
can I
days.
reply?
You have said not within 7 days. Kindly come to the next page.
How can my learned friend give a
21st
reply, my
January.
lord? But
Within 7 days, I have done it. Security deposit and certificates. My learned friend says I have not done it. That is their acceptance.
But I have not produced all the documents which I have.
I
my
am
lord.
showing
I
from
will
his
produce
document.
as for the conduct of my petitioner. But as late as
That's
end
latest
of
too.
my lord, as late as end of January, no application was made from by the petitioner for obtaining NOC.
What my learned
What
friend
my
say?
learned friend
You
is
have
saying, my lord.
confirmed it. Kindly come to, my lord, it is your communication. Kindly come to page 128.
My lord, kindly seize this document, my lord. Kindly seize. This is their document. But all these documents have been suppressed. Kindly seize the date,
আমরা কনফার্ম করেছি
27th of January. They write to IOCL that now you release my vehicles. What does LOA say? Within 15 days, you have to complete the entire formalities. Well, they are trying to earn from both ends.
মানে kindly
They
come to
go, they get a LOA,
at the same
they
time I am
type
giving the
about the
reply.
entire issue, and they say that now you are doing that, you are doing that.
Kindly
and they
come to
are-
page
They
130.
are trying to obtain
This is
the
their communication,
document.
page
Their
130.
document, my lord.
Only one
Their
paragraph, page
document
130.
of 27th of January.
Page 130, they says you have mentioned in tender document so and so.
Complete his submission.
Are
Then
you applying with
I
OMC?
believe that he had indicated that he has concluded with his submissions. I
I'm
have
giving
not
the
yet
reply, sir.
concluded with my sir.
Conclude it, then I shall give reply. Conclude it.
But there are series of emails, my lord, which I am yet to hand over before your lordship. Which series of emails say that you are not complying with it, you are not obtaining NOC. IOCL has also written to us that they have never applied for NOC.
Why? You have confirmed it, page 130. The IFC has confirmed that I have
Their
applied for
document,
NOC.
They can deny their own document. And kindly seize the date of the document.
You can deny your own document.
27th of January.
27th of January.
You have confirmed that NOC has been applied for. Page 124 says all details, their acceptance, security deposit. You have confirmed from the IOCL at page 130. Agreement has not yet been executed with any of the persons who are selected under the same tender.
তুমি বলে দাও না দাদা তাহলে
আচ্ছা, বলো চুপ করে থাকলে তোমার বলতে হবে, তাহলে বলো তুমি। Yes. So your preliminary issue is that already LOI has been issued in favor of other party.
can be.
Third party interest
That
has
also
already been.
even before filing of the writ petition. So whether this writ petition has got its force today or not, I ask this question to myself. If at all my learned friend has to challenge the tender or the selection process, they have to be made party, because third party rights already been created. Lordship, without hearing them today, cannot pass an order, when this document itself are staring at all of us.
Yes.
I did not intend to proceed further and waste the Lordship's time, my lord, because they are emails. My lord, I have got series of correspondence which has already been forwarded, which I can place one after the another to show the merit of the matter and as well as the conduct of the petitioner. But there is a first hurdle to cross, my lord. I will one after another show the conduct, but that is the 1st of February, 27th of January. But 1st of February, but IOCL writes to us.
Copy should be handed over.
No, these documents you just keep yourself. These are the documents.
Yes,
you
ma'am.
have to
These,
serve.
if your lordship at all will hear in the merits, my lord, because then this situation will arise. That is why I did not want to indicate place and trouble your lordship, my lord. Because the first hurdle is a big hurdle that has to be crossed. Because at this juncture, this writ petition has lost its force.
These three persons are already appointed.
Already appointed.
Issued letter of acceptance.
Letter
Letter of acceptance. Letter of acceptance.
So that has
You
been
made party then.
They have not deposited the.
after rejecting them only they have been issued. It's not a
What
case
was
that
that?
parallelly they have been issued.
No, they have challenged the procedure, your rejection.
But
So
requirement has not been filled in. I have not gone through this document. He has not handed over. I don't know if these are all civil cast candidates or not. If you also just hand over me, I can peruse the same. Otherwise, my lord, I can make my
yes,
submission.
yes, no.
This is the new fashion, my lord, without handing over copy only to the court. Because
Well,
I
I
am.
will hand over. No,
Now,
no,
yes,
no
sir.
difficulty. No difficulty.
Your sir.
Because we are at an ad interim stage, my lord, where we are not on affidavits, my lord. At the time of affidavits, all will be disclosed, my lord.
My lord, kindly take up first one. MSc category. Only one reservation. These are all MSc. Kindly see. MSc. I am Silkash candidate. There is a reservation I have shown to your lordship. How many candidates can be given? Kindly turn to my lord page tender document. These are not fair, my lord. Producing a document having no relevancy. I am a civil caste candidate. Kindly see the reservation quota.
page.
Yes, page 43. And now I understood why the copy has not been handed over to me. Page 43, kindly come. 15%, then kindly turn to page 44. After SC carry forward. Total SC quota 17, 8, this is under 12 to 18 and 9, 18 to 24 category. And MSc general, kindly say 6 and 3. Separate. These issues has been given to the MSc category, not to me. Kindly see the middle portion. MSc general, MSc SC, ST, MSc Oman.
You applied for SC category.
Yes. The admitted position. My category, they have not issued any offer letter. The public sector undertaking, placing a document, misleading the court. I am not telling to my learned friend. That has been handed over by the oil company. Kindly see MSC is a separate category. I am SC category. There is the dispute. They cannot do it within 7 days. I have some experience so far these matters are concerned. At least it takes 2 months time to issue offer letter to somebody else. After production of document, fulfillment of all category, other eligibility criteria. It is admitted position. There are 19 vacancies under SC category. And MSC category I have also shown to your lordship. 43, once again, your lordship kindly turn. 44. Total SC quota 17 under 12 to 18 KL and 18 to 24 KL, 9. Then my lord kindly turn to MSc General, MSc S311. This is separate category. Reserved for MSc General, MSc ST.
You applied for SC category?
Yes. There is no dispute about the same. They asked me to produce the SC certificate. Kindly come. I have shown to your lordship once again. Kindly see. Kindly turn to page 124. Verification of MSc certificate and caste certificate. Page 124.
But
No, letter of acceptance says that they have considered you a general category.
That's wrong. That I got that they have sought for this document. First submission was that is wrong. They cannot dispute the same. I am coming SC category.
Where is your application?
kindly come
That I have
to page
annexed.
119.
Kindly come to my application. At
Page
page,
119, my lordship peruses once.
kindly come to my lord page 27.
But kindly sees under what category they have applied for.
Page 1.
Is their document, my lord?
এটা
MSc.
MSc.
আমরা করেছি হচ্ছে MSc
MSc SC. Kindly
Now your lordship sees.
119. My lord kindly turn to page 119.
Now your lordship sees the letter of award aspects which I have just handed over to your lordship.
Kindly come to my lord page
They are
119.
all in MSc SC category and SC
Otherwise,
category.
they should not have asked me to produce the SC certificate and the MSc certificate.
But
page
it is
one-
their document. This is
page-
not my document.
Page 119 is
So
my
their
document.
letterhead produced, applied for by the petitioner.
Kindly come.
Undated document
Kindly
and
come to my
Mr.
lord.
P3 disclosed by them. Kindly see under what category they have applied for.
Yes, MSc SC.
SC.
MSc, yes. And if
And my lord
fulfill
recently
the
said that
SC,
letter
then
of
it will be converted to the
Yeah,
MSc. Kindly come that condition.
You have applied, not applied for SC.
That's the condition. Kindly come. I'm showing to your lordship.
Mm.
If it is filled up, I shall be considered as SC category. Just I'm showing to your lordship. Just I'm showing to you. That is the provision.
Page 119 is the your document.
Yes, my document. What is the provision? SC is that. Well, just I'm showing to you.
sees my letter of provisional letter of acceptance of 14th of February, my lord. Granted MSc SC category. Other one is MSc SC category. Other third one is MSc category. My learned friend, what submission my learned friend is making?
Just I'm showing to your lordship. What is the system?
My learned
MSc
friend
completed,
first
then my lord, it will be converted
first
to
have
the
to
SC category.
satisfy your lordship as regards to the maintainability of writ petition, because I have not uttered
I have
one point on the merits also.
এখন স্পেসিফিক বলা আছে এমএসসি শেষ হয়ে গেলে এসসি তে কনভার্ট করতে but there is a condition if MSc category is filled in then my lord SC category will be converted to that category. Just I'm placing the road. That is there. Just I'm giving you. Actually, SC category is very specific.
Lordship now is well aware of the law laid down by the Honorable Supreme Court. But the read court will only interfere and only if there is utter arbitrariness that has been shown. Otherwise, it
My
law is laid
my
down that the
friend is
tendering
going on
authority is the base judge of its requirement, and the administrative decisions which have been taken by the tendering authority should not be taken into consideration by the
SC category has
Constitutional
not
Court
been filled
until
in.
and unless there is sheer
That's the
arbitrariness.
case. হাত মারা ছিল আমার Well, 1 second, if you click. Forward it. My lord, kindly turn to my lord, page 44. No, that is not good. That is not good.
Page 44.
But just I'm showing you. My learned friend knows he is not basic with your lordship. This category will be immediately converted to the SC category if NSC is filled in. That provision is specific provision is there. So I am now following from SC category where 17 plus 9 vacancies are there. My learned friend has produced before your lordship only MSc. But it is admitted position, my lord, SC has been not filled in. My learned friend failed to produce any document that the SC category has been filled in.
But they have considered you as a general candidate.
That cannot be. That's my specific case. Otherwise, they should not have asked me to produce the SC certificate. At thrice they have shot for, and I have produced the same. My application is SC.
Application is MSc SC.
MSc SC. MSc SC, my lord, one. If it is filled in, then my lord, general category, SC category will be taken place. That's the observation.
You read page 119.
My lord.
Read page 119.
119 is my application.
No, you just read. This is the pro forma of declaration.
Yeah, my lord, kindly turn, my lord. I'm grateful to your lordship. I'm grateful. Serial number 4. Readers under MSc SC categories will consider for evaluation SC category in following scenario. Entire quota of MSc is exhausted. The fulfill all norms of belonging to us. So MSc filled in, then I shall be treated as my lord SC category candidate.
So when they issued the LOA, so
They
the
only to
quota,
the MSc candidate.
the quota was not exhausted, I think.
Yes, that's my specific case. They cannot. They cannot. These are all previous occasions. They have selected along with me. They are showing the document that who have selected is not me in my place. They are showing a document before your lordship in respect of the candidates who also applied for me under the SC category.
No, LOA said you are acceptance your LOA under general category.
It's wrong.
That is wrong.
As applied by you.
That is wrong. That is my specific case.
Is that issue under challenge before your lordship?
No, no, yes,
Huh?
yes,
Is
yes.
there
under
one
challenge.
single document
Yes,
my learned friend is showing
Yes.
that
Yes,
see, I have lost my protest?
Yes. What protest I have categorically stated? I have to come within 7 days. You are saying I am late. If I made a representation, I have to wait another 1 month. My specific case is that kindly come to my lord where I pleaded
Paragraph 7,
paragraph 7.
page 7.
Page 7. Is it his case that I am a general category? Page 7, kindly come.
No, you applied for MSc.
MSc. And if the MSc category filled in,
Candidates who have been granted in under same category.
if the MSc is filled in, then my lord, I shall be considered as general category, SC category. That I have lordship has sought.
Already filled in. My learned friend had offered.
My learned friend has not
seven
produced any
trucks.
document
Three
showing.
tenderers have been granted now. 2, and 3.
Under which category? MSc category.
You applied.
Why
for
my
MSc.
learned friend is showing my MSc category? Because he is considered me MSc category. But in the offer letter, general category. In that case, my learned friend should have brought before your lordship the general category appointment. If they consider me general category, let them consider me general category. Where is the document?
Learned friend can play at both ends now.
No, yes.
Once he's
You
arguing his
admitted
case
why
that
you
I
are
was
producing a
I
document
was
of
a
MSc
SC.
category,
Then
but
documents
not SC
produced
category.
showing that he applied for MSc SC. Now my learned friend
No,
is
no,
saying,
MSc SC, I am always
me-
saying.
let me be a
I am saying you have
as a
brought the
general
document
candidate.
of MSc, not the SC. You have also not brought the general category because you know I am a MSc, SC category candidate. That says page 119, serial number Roman 4, rightly following for your lordship. For acknowledge SC category in following scenario. Entire quota of MSc is exhausted. Then I should be treated, my lord, 19 and 6. They failed to produce any document so far the SC category is concerned. He let us produce the SC certificate. Now he is saying it is not wrong. Verification of caste certificate. What does it suggest? Verification of SC certificate. This is their letter I am showing from my repetition.
সার্টিফিকেট আছে 124 দেখুন 124 পেজ 124 এমএসসি সার্টিফিকেট কাস্ট সার্টিফিকেট
Page 124, bottom portion.
What is your prayer now? Here.
To grant,
What you
cancel
want?
the offer letter. Cancel the cancellation letter. Kindly come to page 123.
There are two scenarios that emerges.
Let my learned friend conclude. This is a following from your lordship.
According to us, my lord, the writ petition has become infructuous. There are third-party rights which have been created. Lordship behind without hearing them. At this juncture, with deepest of respect, no order can be.
I am not belongs to
Second-
my lord MSc category.
Okay, just wait.
Second is, if your lordship intends to hear the matter on merits, but the intending bidders who have already been selected, my lord, they have to be added as parties because all have to be heard, and lordship will give directions. The first steps they have to take is to bring them on record. Lordship hears them whether the writ petition still remains maintainable or not. Or in that, if my learned friend succeeds, my lord, it has to be heard on affidavits, my lord. Today at a prima facie stage, my lord, without documents being placed on oath, my learned friend has made certain pleadings in the writ petition. I need to get a chance to controvert them.
Yes.
There are many pleadings that have come, that those are disputed questions of facts. As on today, read court, my lord, the scope is very limited. Prima facie lordship will see their sheer arbitrariness. That is not the case. With deepest of respect been made out by my learned friend, my lord.
Kindly come to
I
page
have demonstrated at the face of it, my lord, that now LOA has been issued in favor of third-party rights, and the dates are very important before filing of the writ petition. Had it been the case, 18 writ petition had been
No
filed.
agreement was executed in
No,
respect-
no agreement. And that too, my lord, there was no mentioning that in place of cancellation of the previous tender. Kindly take note because these are not SC category. All are MSc category. Kindly come to page
MSc category, my learned friend has applied for.
Okay,
These
okay,
7 candidates.
SC, MSc. Kindly,
I have understood.
but page 23 is the my pair, my lord, interim pair. H and J. Page 20. Not a single document showing that the SC category candidate has been offered, issued offer letter.
Okay, please take down.
At page 23.
HPCL floated a tender for transportation of bulk POL products. POL products. Capital MS stroke HSD and branded fuels by road ex Holdia terminal for a period of 5 years WEF with effect from 01/01/2025 up to 31st 31/12/2029. Petitioner participated in the tender. He received LOI on 23rd of December 2024. Petitioner deposited the security deposit, placed the original MAC certificate stroke trust certificate, and also placed the original documents of truck tanks within bracket TT. The concerned authority, a respondent authority, has received the secure deposit and physical verification of TTs has been done at Holdia terminal. It is the case of the petitioner that he placed 7 TTs in terms of the tender. Among them, 5 TTs are plying with another oil company, that is IOCL, Holdia. The petitioner, by letter dated 29th January 2025, requested the respondent authority to sign the agreement, which was signed by him, unless which the IOCL would not issue the NOC in favor of 5 truck tanker TTs which were plying with the IOCL. Thereafter, via a input communication dated 7th February 2025, the respondent authority has informed that the LOI issued in favor of the petitioner stand cancel for non-placing NOC in respect of 5 track tankers, 5 TT within the stipulated period. It is a positive fact of the petitioner that the provisional letter of acceptance specifically formulated the steps to be taken by the petitioner, wherefrom it would be appeared that first of all the petitioner had to deposit the security deposit, amount of security deposit. Thereafter, he has to deposit the MSc or cash certificate, and he has to place. Thereafter, he has to place the original document of TTs. It is a case of the petitioner that after verification of the TTs, the agreement has to be executed between the parties, and thereafter NOC of the TTs would be submitted, will have to submit it before induction. Full stop. Petitioner submits that as the agreement was not executed by the respondent, he faced difficulty for acceptance of NOC from the IOCL in respect of 5 TTs. He submits that the IOCL, the respondent authority himself, not followed the conditions of tender. Thereby, the impugned communication dated 7th of February 2025 regarding cancellation of provisional letter of acceptance in favor of the petitioner is highly act of arbitrariness by the respondent authority. He prayed for necessary order for setting aside the said communication. Mr. Vishwanath Chatterjee, learned counsel, appearing on behalf of the respondent authority, submits that the incident petition was filed on 18th of February 2025. Prior to that, that is on 14th of February 2025, the respondent authority, after cancellation of LOI, has issued issued letter of acceptance in favor of other 3 persons, other 3 entities. He submits the third party interest has already been created prior to the third party interest have already been created before filing of the incident writ petition. Thus, the writ petition became infructuous. Having heard the learned counsel for the parties, it appears to me that having heard the learned counsel for the parties, the respondent authority is directed to hand over the copies of document which was placed before this court regarding issuance of provisional letter of acceptance just before the filing of the instant writ petition. Full stop. Obviously, the third party interest has already been created. any order stroke direction passed by this court shall affect the third parties in favor of whom the provisional letter of acceptance has been letter of acceptance have already been issued on 14th of February 2025. Under the above aspect, the petitioner is directed to incorporate the three entities in the instant writ petition as a party respondent by serving the
To whom I shall make parties, my lord, that details my management should. be
details.
sent.
They have you handed over the copies.
Now उसमें जोड़ के दे दीजिए. May I take that, my lord?
কবিটা দেয়া আছে
Not direction में दीजिए.
কোনটা কোনটা দেয়া আছে well I'm handing over
Yes,
কোনটা রাখো না
I have two copies.
but there are three. One is Kobe Transport. One is Kobe has my learned friend has handed over. I'll take back my lord. That let those kept on record, my lord.
Yes, give me three copies
Three.
and hand over three copies.
Very well, I'll do that. One is
Kopi
Kobe Transport, Atto Shakti, Komula Kante. Well, I already hand over three of them.
Detail address is not there.
as a respondent, and serve the copy of application, serve the writ petition upon them, informing them that the matter shall appear in the list
Not different. Next week.
11 on 11th of March 2025.
At 10:31.
11 or 10:30, I have fixed your matter, another matter.
Second matter.
Under the same heading, to mention,
As your lordship, 2 minutes.
under the
I'm
same.
get. पाशे आगे रखा है. Please. But may I pay only one thing?
Well, a point of maintainability we kept open.
Not to execute the agreement in the meantime. Because the agreement took.
Well, I'm opposing.
I do not know whether agreement has been.
That also we do not know. That also we
That is
do
their
not
case.
know.
Only offer letter has been issued. Not to execute the
Not in my case, my lord. There
If
is no
they
scope of any.
executed, then the.
Not yet. If not,
Well, my learned friend.
if not yet, if
The
not yet,
learned
then
friend
not
cannot
to
dictate my lord. The lordship
Because
own my lord.
after execution of agreement, whatever I shall submit to your lordship.
It will abide by the fate of the writ petition.
That
It will abide by the fate of the writ
tally
petition.
record if not yet executed.
No, my lord. Interim order, my lord. I
Then, my lord,
strongly.
tally is-
I
It has
strongly.
not been executed.
I am opposing, my lord. I have to. That is why I indicated the point of maintainability be kept open.
Okay, very.
Oblige,
Tally
my
record,
lord. No
any
interim
steps- Any steps taken shall abide by them. Mr. Tally record.
Okay, please take down.
Well, the point of maintainability be kept.
Point of maintainability as raised by the learned counsel for the respondent kept open. The decision, any step taken by the respondent authority in respect of the tender procedure shall be abide by the result of the writ petition.
Very.
My lord, there is a mail address of the court. I shall have serve the copy mail. Kindly record it, my lord. Otherwise, they may come and say. Since there is only mail address, I cannot.
Only mail address is
Yes.
there.
And nowadays, my lord, everything is online.
I shall keep
The
copies.
learned friend also
Mail
knows.
is acceptable. Okay. The
Sure.
petitioner is at leave to serve notice upon the entities through mail.
To the added respondent.
Upon the
But the-
entities, three entities.
But
They are
the
not
learned
added
friend has to
yet.
take steps, my lord, for adding them as party
I have already talked.
নাম অ্যাড করে দেবো
হ্যাঁ নাম করে ইমেল দিয়ে দিবে
নাম অ্যাড করে
এই অ্যাড্রেসটা দিয়ে দিবে
Next,
টিপটা দেবে কারেকশন
oblige, my lord.
Oh,
আদার সাইড যদি থাকে না স্টার্ট করলে চলবে আদার সাইড যদি কিছু My lord, I appear for the petitioner.
Yes.
My lord, I was addressing your lordship on the facts. My lord, this is the matter about the administrative staff at Bose Institute. My lord, I said that there are two limbs of the facts. That one regarding implementation of the revised pay pattern structure and career advancement policy, and the other was illegal withdrawal of the same policy, which commenced in the year 2019, but it has its genesis in 2017. That is with implementation of the 7 CPC. My lord, on the last occasion, I have dealt with the first limb of my factual submission. I have started with the August 1979 document issued by Professor MGK Menon, where my lord, it was decided by the then secretary that there has to be parity in policy decision between IACS and the Bose Institute.
Yes.
Well, thereafter, I have taken a lordship through how the Structural Reforms Committee was formed with the liberal support from the DST, and my lord, how the SRC's recommendations were placed before the Finance Committee. Finance Committee has approved it. Then the matter moved to the Council. Council in 170th meeting approved it. When pursuant to that, my lord, in April 2008, this policy was implemented, subject to, in anticipation of the formal approval. My lord, then 6 CPC implemented, and eventually, my lord, the revised pay structure and my lord, career advancement scheme, as well as the 6 CPC recommendations, were approved by the council in its 171st meeting,
Yes.
which was convened on 29th of October 2008.
Eight.
Right, this is where I concluded on the last day. Well, just for brief recapitulation of your lordship and just to refresh our memory, I have prepared a very short chronology of events. I'll quickly take your lordship through the sequence. Kindly see the serial number 1. It refers to the 1979 notification. I have referred to that. Then 1999, delegation of power from DST to the governing council of the respective autonomous organization. For what? Through that notification, administrative matters, some powers were delegated to the governing council as far as administrative matters were concerned. And complete freedom were given to the council as far as the service condition of group B, C, and D employees were concerned. For group A employees, there were certain restrictions for which they have to take approval. Then came the 7th and 8th July 2006 recommendation made by the Structural Reforms Committee. Where the Structural Reforms Committee, serial number 3, constituted for reviewing the pay pattern and service condition of employees at Bose Institute, has submitted its recommendation. The SRC has recommended that pay structure and other service condition has been amended at IACS. IACS being a sister concern under the DST, completely at par with Bose Institute. Thus, the revised pay pattern and other service conditions may be adopted at IACS at Bose Institute at par with the IACS. These were the recommendations. Eventually, these recommendations came up for consideration before the Finance Committee, which is the nodal authority for taking any financial decision at the Bose Institute. My lord remembers the composition of the Finance Committee. It comprises of the financial advisor DST, Joint Secretary and Financial Advisor, the AG Bengal. My lord, then the director, and my lord, I'll just there was one more member. Then the additional Chief Secretary, Higher Education Department, Director, Bose Institute, and the Registrar. So, the financial implications of any decision taken by that particular body has duly been kept into consideration by the authorities in 2008. It is not a fact that without taking in any without taking into consideration the financial implications, the authorities have proceeded on their own. Then the next, on 7th of January, the recommendations were placed. What was held on that day? The recommendation made by the SRC was placed before the Finance Committee, where the director has drawn attention of the financial advisor DST to Professor MGK Menon's letter dated 8th of August 1979 and submitted that in view of the said policy decision, further deliberation on the SRC recommendation were unwarranted. In this backdrop, the director has urged the Finance Committee to implement at Bose Institute the revised pay structure and other service benefits as invoked at IACS. The Finance Committee agreed to the points urged by the Director. As such, decision will have automatic approval of DST pursuant to the OM dated 8th August 1979 and place the matter for final consideration at the extraordinary meeting of the Finance Committee scheduled to be held on 31st of January 2008.
Yes.
Well, only for this purpose. And now extraordinary meeting was convened on 31st January with sole agenda for approving this. But eventually, serial number 5. After detailed deliberation, Finance Committee arrived at the conclusion that so long Professor Menon's OM dated such and such was in force, the parity between Bose Institute and IACS in terms of the pay scale and other service conditions should be maintained and enforced. Thus, committee resolved to communicate its view to the Council of the Bose Institute. Finance Committee approved. Matter now moved to the Council. The Council in its 178th meeting, which is serial number 6, on 21st of March, had the occasion to consider this recommendation. The minutes of the Finance Committee meeting held on 7th of January and 31st of January 2008 were placed before the Council of the Bose Institute. The Council, presided over by the then Secretary, has agreed that there should be parity between IACS and Bose Institute in terms of pay and other benefits of staff as indicated in the letter from Professor Menon, the then Secretary. Well, this is the only meeting that the authorities have considered while revisiting the 2008 policy. They said that they were contemplating that there has to be parity between all the autonomous organizations, and for that purpose, the ministry will take appropriate steps. This is how they have interpreted this meeting or this council meeting. But after that, serial number 7, we have implemented the revised pay structure and career advancement scheme pursuant to the discussion that was arrived at in the Finance Committee meeting and the Council meeting. Now, after this, 6 CPC was implemented.
Yes.
On 17th of October 2008, serial number 9. Serial number 7, policy implemented in April. Serial number 9, 6 CPC based on the same policy implemented at Bose Institute, serial number 9. Eventually, these 2 steps taken by the institute was duly approved by the council in its 171st meeting on 29th of October 2008. And the authorities conspicuously kept silent about it. I put a question to myself. I've shown on the last occasion that the entire group of officers, deliberation. They said deliberation. I said it was just mockery. Without considering a document, which is apparent on the record. It was there before you. There is no whisper about a particular document, which in my respectful submission is the most important document. And based without considering that document, you say that document does not exist because you say that there was no approval. And you went on to pass an order declaring my 2008 policy to be null and void for want of approval. So, the eventually approval came on 29th of October 2008, serial number 10. The council in its 171st meeting presided over by the then secretary have duly endorsed the decision taken by the respondent institute regarding adoption of revised pay structure and career advancement scheme for the non-academic staff. The 6 CPC, which is the subject matter of challenge in the other writ petition before the coordinate bench, they have shown the order. In our case, the recommendation made by the 6 CPC based on the 2008 policy, it has due approval by the council, which comprises of the then secretary. If the then secretary DST, if the then secretary DST was sitting at the helm of affairs, what better approval you can have? And now, who is challenging this, my lord? Who is reopening this issue? A deputy secretary. It's almost like a civil judge, a learned civil judge, junior division is reopening the issue decided by the learned district judge.
Yes.
I'll come on these points of jurisdiction and the legal points, legal challenge. I'll come, but today I'll take my submission forward from where I left on 29th of October 2008.
Yes.
And that was the first limb of my submission. Today I will reopen my submission. Now I'll address the second limb of facts which has unfolded. Rather, I can attribute this to be the illegalities perpetrated by the respondent authorities to undone the benefit that my clients have received in terms of a duly implemented policy decision in the year 2008. My lord, this unlawful exercise started in the year 2019, but my lord, it has its genesis in 2017 because they are doing it in the guard of implementation of the 7th CPC. So my lord kindly takes the serial number 11, which is a office memorandum issued by the Department of Expenditure on 13th of January 2017. Your lordship will find this document. My lord, better copy is available at my lord, annexure R4, page 29, affidavit in opposition by Bose Institute. This is right, affidavit in opposition on behalf of respondent number 224.
Page,
Right, page 29.
yes, I've seen that, Ministry of Finance.
My lord, this for my convenience, my lord, and I'll just place it for my satisfaction rather.
Yes,
My lord, this is the document and from 2008 October till 2017 January, or rather 2019, because my policy was withdrawn in 2019, my clients were enjoying the benefits, and rightly so. In 2019, the authorities woke up from their slumber and they decided, let us make some adventure. Well, they have drawn the authority to this document. They say that if you want to implement the benefits under the 7th CPC, you have to comply with the mandate under this. Well, very well, you can. There is no, for the sake of argument, I don't stand to this. I don't object this. It's a policy decision. 7th CPC you want to implement, you can look for certain requirements, but it has to be prospective. Well, this 6th CPC, my lords knows that for the central government employees, it was implemented in 2016. But for autonomous organization, there is no automatic approval.
yes,
It's a subsequent exercise. And this point, my lord, kindly take note of this point, because I will, my lord, develop my argument on this, that the central government policies are not automatically applicable to the autonomous organization. Because I have got autonomy. If I am put into that bracket of with a central government employee, my autonomy to deal with my own affairs will not stand. So, my lord, kindly seize the subject. Pay division of employees of quasi-government organization, autonomous organization, statutory bodies set up by or funded by the central government, guidelines regarding. Well, the first para, the employee working in quasi-government organization, autonomous organization, statutory bodies set up by the central government are not central government employees. What I made my submission on. Therefore, the benefits implemented by the central government in respect of the central government employee as part of their service conditions are not directly applicable to the employees working in such autonomous organization. The application of such benefit or as given to the central government employees in respect of employees of such autonomous organization, as well as the manner and conditions governing such application, including sharing of additional financial implication arising thereon, requires specific approval from the central government. Now, my lord, kindly comes to the second para. It is in the above background, the question of extension of the revised pay scale in terms of CCS revised pay rules 2016. My lord, with each pay commission, you have get this rule, a new rule is framed. Well, each rule has to be implemented prospectively. One pay commission cannot encroach upon the mandate of the previous pay commission. Well, this is settled now. You have got this scope and mandate to recommend prospective pay pattern of any organization. You can't go, because this document nowhere speaks or gives any authority to the concerned persons to dig in past and tinker with the existing pay pattern in the under the previous pay commission.
Yes.
So, my lord, as noted, this rule was notified on 25th of June 2000, so July 2016, in respect of central government employees, based on the recommendation of the 7th CPC to the employees of quasi-government organization, autonomous organizations, statutory bodies, etc., set up funded by central government, where pattern of emolument structure, that is pay structure and allowance, in particular dearness allowance, house rent allowance, and transport allowance, are identical to those in case of central government, has been considered by the government, and it has been decided that the revised pay scale as per the pay matrix as contained in Part A of the schedule of the CCS RP rules 2016, as well as the principle of pay fixation as contained in the said rule, may be extended to the employees of such organizations, subject to the following stipulation. Well, kindly take note of the first stipulation. The conditions of service of employees of these organizations, especially those relating to the hours of work, payment of OTA, etc., are exactly similar to those in case of central government employees. Well, it no way talks about promotion policy. This is one of my arguments. Well, it now kindly comes when it comes to para 4. This para 4 is important to understand the true scope, as in the terms of reference within which the group of officer has to navigate. And any authority, be it quasi-judicial authority or judicial authority, draws its authority from the statute or from the parent document. This being the parent document, para 4 lays down the outline, the scope. It's very important, my lord. In case of those category of employees whose pattern of emolument, structure, pay scales, and allowances and condition of service are not similar to those of the central government employees, a separate group of officers in respect of each of the autonomous bodies may be constituted in respective ministry bodies. I'll pause here for a moment. The first hurdle, my lord, is you have to find out, it's a jurisdictional issue, whether there is a disparity or not. They have not done it. I'll show in the course of my submission, my lord. The next point, the financial advisor of the respective ministry department will represent the Ministry of Finance on this group. Again, my lord, very important point. My lord sees the Department of Expenditure has put its faith on financial advisor of the respective administrative ministry. My lord, during the course of my submission, I have made great emphasis on the fact that the previous policy decision was made under the aegis of the financial advisor. If your lordship might kindly recall, the first finance committee meeting was the chairman was the additional health secretary. Additional secretary hired education department, government of West Bengal, but the active member, who was the prominent member, the joint secretary and financial advisor. Again, my lord, the council, it comprises of the secretary DST. It was chaired by the secretary DST, and financial advisor was also part of that council, which has approved the policy decision. So, my lord, if today they put their faith on the financial advisor, that the financial advisor will be the right person to take note of anything that may go against the interest of the Ministry of Finance. So, my lord, he was there. So, after that, my lord, the group would examine the proposal for revision of pay scale, etc., taking into account the views, if expressed by the staff representative of the concerned organization. My clients, my lord, belong to the administrative cadre. My lord, this is my specific case on instruction. My lord, there was no representation before the group of officers. My clients were not heard. My client's representation were not considered. So, my lord, with this mandates that any decision has to come only upon taking views from the concerned employees. Now, my lord, next, it would be necessary to ensure that the final package of, my lord, kindly note this, the final package of benefits proposed to be extended to the employees of these autonomous organizations. My lord, the word proposed itself shows that it's prospective. Your scope is very limited. What package you propose as on date, whether that package, that financial package, found to be in parity with the other central government employees or not. Well, this is without prejudice to my submission that there is no disparity. But even otherwise, your scope is very limited. If you propose something, if there is disparity, then you ask the authority to bring in parity, then you will implement. No scope to go back in past and nullify a validly implemented revised pay structure policy, which was duly implemented at Bose Institute in 2008. Now, my lord, is not more beneficial than the admissible to the corresponding categories of central government employees. The final package by this group of officers will require the concurrence of the Ministry of Finance. So, my lord, this paragraph gives us 4 points. I have emphasized. My lord, number one, first you have to decide on the jurisdiction, whether there was any disparity or not. If there is a disparity, then we move on the next step, forming the group of officer. First, assess disparity. Next, form the group of officer. No disparity, no group of officer. Well, at the third point, financial advisor has been given this, or he has been bestowed with the faith that he will take the correct decision as far as the affairs of the institution is concerned. Well, at my submission, all the previous policy decision in Bose Institute, which was implemented in the year 2008, had the due concurrence and approval of the then financial advisor. Well, at number 3, it says that while carrying out this exercise, you have to hear you have to consider the views expressed by the staff representative. Was that done? This will be one of my arguments. And lastly, it refers to the proposed package. There should not be any disparity as far as the proposed package is concerned. This now binds the proposed group of officer. They have to travel within the scope of these 4 corners, these 4 points. They cannot go beyond that. Now, in terms of this Department of Expenditure circular, paragraph 4, very important. Now I'll take your lordship to the composition of the group of officer and its meeting, which was held on 24th of June 2019. And the group of officer was constituted on 5th of March 2019.
Yes.
I'll not trouble your lordship with the composition, the document composing the group of officer. I'll straight away take your lordship to page 34. In terms of this January 2017 circular, they have started the process to nullify, or rather a misadventure to prejudice the interest of my clients by forcefully withdrawing a subsisting policy in 2008. Now, my lord, page 34. My lord has that?
R5.
R5, page 34. My lord, this is the minutes of meeting of the constituted group of officer for examining the proposal of Bose Institute, Kolkata, for revision of pay scales of technical and administrative employee.
Yes.
Well, dated 24th of June 2019. And it kindly sees the composition. Members present.
Yes.
Well, the composition of the group of officers at the left hand side column, which says Dr. B.K. Shukla, Scientist G, Head AI Division, DST, in the chair.
Yes.
Then Professor Dr. Uday Bandopadhyay, Director, Bose Institute, member. Number 3, Sri S.K. Sinha, Director, Admin, DST, member. Then next, Sri Pulok Sen Gupta, Under Secretary, IFD, DST, nominee of AS and Financial Advisor, member. This is the composition. Then I don't know from where they got this invitees from DST. I could not find any provision for that, but be that as it may, there were 2 nominees, Dr. Mohanty and Sri P.K. Singh. And then At the right hand side column, my lord, representative from Bose Institute, Dr. Shubhashish Banerjee, Technical Officer 1, Professor Anup Kumar Mishra, Registrar, Officiating, Srimati Nudin Bhattacharya, Deputy Registrar, Shri Ochinto Mukherjee, Accounts Officer, Shri Vikas Kumar, Accounts and Finance Officer, Shri Devdas Nondi, Assistant Registrar. Well, where is the representative of the administrative staff? I understand the serial number 1 is the representative of the technical staff. Where is the representation from the administrative? There is none.
Assistant Registrar?
Well, it's all part of administration. Well, perhaps they are not hampered. They are not subjected to this policy. And my lord, this is my categorical case. My lord, he is not subject to my lord correction. He is not our representative. He is part of administration, but not the administrative staff. Well, there is a difference.
I understand.
My lord, the next para. My lord, kindly take note of this. No representation on the part of the administrative staff, because this will again, my lord, challenge clause 4. In pursuant to the DST OM number such and such dated 5th of March 2019.
Yes.
This 5th of March 2019 is the memo through which this group of officers was constituted. The constituted group of officers in respect of Bose Institute, Kolkata, held its first meeting in Technology Bhavan, New Delhi on 24th of June 2019 at 11 am. My lord have heard this matter at length. My lord, this is not the first meeting. This is the first and solitary meeting that the group of officers has convened. Normally, Dr. Mohanty is not part of the group of officers. But Dr. Mohanty is invitee, but he's, look at the para. On behalf of DST, welcome Dr. Shukla, the chairman, and all members of the group of officers. And after formal introduction of all the members, the invitees present started the meeting with the permission of the chair. The para 3. The representative from Bose Institute placed the desired information as called by AI Division, DST, by its email dated 14th of June 2019 before the group of officers. On perusal of the furnished document, the group of officers observed that the technical and administrative employees of Bose Institute were having service conditions such as time scale promotion. Kindly mark this point, madam. The disparity they have referred to in para 4, what is the disparity? The scope of disparity is only that my clients were enjoying time scale promotion. This is the bone of contention.
Yes.
Well, this time scale promotion as per Bose Institute OM number such and such, dated such and such. From the content of the OM dated 8th of April 2008, group of officers found that the order was issued to have pay and career advancement structure parity with that of employees of the Indian Association for Cultivation of Science. The date of implementation of the order has been taken the same, that is 22nd of December 2005, as that of IACS Kolkata. Para 4. After deliberating on the furnished information, the group of officers observed in compliance to DOE circular dated 13th of January and opined that it would be better to have the chronology of events from BI which led to adoption of time scale promotion in lieu of vacancy based promotion for the employees with effect from 22nd of December 2005. Well, I'll pause here for a moment. I put this question to myself. Was it their scope? Was it their term of reference? What policy was prevailing back then in 2005? Does it have anything to do with the scope and jurisdiction of the group of officers? Well, in my respectful submission, answer would be negative. Well, clause 2. The document related to origin of structural reforms committee, such as need for the structural reform committee, its constitution, its mandate, minutes of its meeting, final recommendation of the SRC, its acceptance, well, in bracket signed copy by the members. Well, they are insisting for the signed copy, but my lords, remember, group of officers, it's not a completely signed copy. the acceptance and approval by the DST, etc. The reason for bringing such change in the designation of the post in BI may be brought out. I have shown to your lordship how the 2008 policy was implemented and in what backdrop the SRC was constituted. The difference in service condition post 22nd December, pre 22nd December. My lord, next is important. Next, page 35, para 5. Now, this is important for our purpose. These three are assumed for a moment, my lord, they don't have the jurisdiction. My lord, without considering to the fact that they have jurisdiction to get into this issue. But be that as it may, my lord, these 3 points, para 5 says that you bring a mapping in tabular form to assess whether there is a disparity or not. And para 6, while presenting this tabular statement, the authority were called upon to present the views of the staff. If the staff view are not presented with that tabular form, you present it in Roman 7 separately. These 3 clauses. My lord knows that a tabular chart was presented. I'll present it. But before that, I'll show to your lordship the next step the group of officers have taken. My lord, in my respectful submission, para 5, mapping in tabular form was presented. There was no disparity. Still they proceeded. That I'll show. My lord, para 6, 7, staff views never ever presented before the group of officers. And my lord, kindly consider the last point. These documents were called. The authority, the group of officers has called for this document with an intent to consider and deliberate. My lord has seen para 4 of 2017 January document. There has to be a deliberation. And what do we mean by deliberation? Certain documents were sought for. After that, it is least expected from the group of officers to convene another meeting. Once the documents are received, give the staff an opportunity to present their case. Only upon hearing the staff side, they would have to first consider whether they, considering the tabular mapping, whether they have jurisdiction or not. Then they would consider, assume, even if they wrongly decide that I have jurisdiction, then only they can proceed. There has to be a finding. You have to return a finding on the jurisdiction, whether there was a disparity or not. Nothing has been done. Then they will consider the staff representative. All these things will be done only when there is a consultation process. After 24th of June, let them show a document that they have ever assembled. This group of officers ever assembled after 24th of June 2019. What kind of deliberation is it? Where is the consideration? No one should be condemned unheard. This is the basic principle we follow. The principles of natural justice. But after 24 June, nothing. Straight away, group of officers comes with a report. My lord will find that report in the affidavit in reply filed by my client against respondent number 1. My lord, kindly take that.
This is the sole meeting.
My lord, this is the only meeting. My lord, I have shown. My lord, kindly see para 5, 6. What documents were sought for? Keeping in view the duties and responsibility of post in both institute with that of corresponding pay scale, BI shall propose for devised pay scale for respective post in 6 CPC. Who have given you authority for 6 CPC? They exceeded their scope. And 7 CPC along with detailed justification for consideration of the group of officers. Group of officers is a creature of the CCS revised pay rule 2016. Nothing to do with the previous pay commission. While making such proposal, it shall ensure that the final package of benefit proposed for its employees shall not be more beneficial than that admissible to the corresponding categories of central government employees as per DOE OM issued from time to time. For better appreciation, mapping in tabular form may be submitted showing the pay structure and post with duties and responsibility prevailing in both institute with that of structure of pay, etc. prevailing in any government of India lab organization in bracket such as DRDO, DAE separately for technical and administrative staff. My lord knows there is a tabular mapping presented before the authorities, the group of officers rather, drawing a my lord, comparison with the DRDO, which is a pure central government research body. And my lord, in my respectful submission, even for my client, there is no disparity. My lord, next, while sending the proposal as mentioned in point 5, my lord, they are calling for a proposal. Above, the view of the staff side, if any, shall also be considered, and if deemed fit, shall be included by BI, and a certificate to the effect that the forwarded proposal includes the views of the staff side may be placed. Never done. Roman 7. In the event views of the staff side not included in the proposal to be sent by BI, then the same may be placed as separate annexure with the proposal for consideration of group of officers. So much scope has been given for the staff to make their representative, but eventually for nullity. Well, any other document or note which, in the opinion of both institutes, shall be helpful to Ministry of Finance for better appreciation of its case. Representative from BI assured to furnish the document as required by the group of officer by 15th of July 2019. The meeting ended with a vote of thanks by Dr. Mohanty. I don't know who is Dr. Mohanty. He is not part of the group of officer. So, my lord, this is the case. First meeting, only meeting. My lord, now comes to the report. I don't know whether these documents were submitted. It is submitted, but when did the group of officers got the occasion to consider these documents? In their private respective chambers. My lord, a deliberation cannot happen in the respective chamber of these high officials. They have to take the pain for the employees. They have to assemble. They have to then decide on the fate of hundreds of employees. They cannot do it so callously. Well, it kindly takes page 14 of the affidavit in reply.
Draft report.
My lord has rightly pointed to the appropriate thing, draft report. Let's see the seriousness with which the high government officials have worked for the interest of these Group CD employees. They don't have the voice. They can't stand up against the senior officials from the ministry. But see the seriousness of the higher officials. Well, this is report of group of officer constituted for considering and recommending grant of 7 CPC to the technical and administrative staff of Bose Institute, Kolkata. But there are number of marking, overwriting, crossings across the draft. And in my respectful submission, my lord, the draft is only meant for circulation amongst the members. And it can only come after due deliberation amongst the concerned members and due consideration of the document, which never happened. Now, Department of Science and Technology, in terms of DOE Office Memorandum dated 13th of January 2017, wide its OM number such and such, has constituted the group of officers in respect of those autonomous institutions under DST where the non-technical administrative employees were enjoying promotion avenues better than employees of central government. My lord, again, kindly mark what is the bone of contention is the promotion policy. My clients were enjoying time scale, and this is the issue the DST has, the respondents have. My client cannot enjoy time scale, which I show to your lordship. It's not alien to the survey jurisprudence. Now, my lord, kindly sees the composition of the group of officer. Additional Secretary and Financial Advisor, DST, or its nominee, Dr. B.K. Shukla, Head Autonomous Division, or his nominee, Shri S.K. Sinha, Director Administration, DST. Now, Director, Registrar, Administrative Officer, nominee of the Director of the Institute. My lord, this body comprises of 4, but this document is signed by 3. Incomplete deliberation, incomplete consultation, which will eventually vitiate the report itself. I have my judgment to that effect, which I'll show when I'll deal with the points of law. Now, my lord, kindly sees para 3(2). The meeting of the group of officers in respect of the Bose Institute was held on 24th of June 2019 at DST, New Delhi. The list of participants attending the meeting is annexed as Annexure 1. Only meeting, no dispute. Now, para 3. The terms and reference of the group of officers was to examine the pay packages of the respective autonomous bodies, taking into account the views expressed by the staff representatives and ensure that the 7 CPC final package of benefits extended to the employees of these autonomous organizations is not more beneficial then admissible to the corresponding categories of central government employees. The proposed final package that you intend to give to the autonomous organization, they should be parity with the central government organization. The tabular mapping shows there was parity in terms of the promotional policy, as in the residency period, that is the bone of contention. The final package recommended by the group of officers would be submitted to the AS and FA for further concurrence of the Ministry of Finance. The scope was again reiterated, nothing new. It has very limited scope to consider proposed financial package. Next, kindly then take para 7. I'll not trouble with the subsequent paragraph. Kindly take para 7. Acting Registrar Bose Institute stated that non-academic technical employees of Bose Institute were given time scale promotion since 22nd of December 2005. Before that, kindly takes para 5. Professor Anup Kumar Mishra, Acting Registrar Bose Institute, stated that AI Division DST, via its letter dated 7th of Feb 2019, has directed autonomous institutions under the DST to withhold the 7 CPC benefits where vacancy-based promotions are not followed in respect of non-technical administrative employees, and such staff are enjoying better service condition on promotional avenues than that admissible to the corresponding categories of central government employees. The grant of 7 CPC to be put to hold till GUO recommend the case or otherwise. This is on the premise that my client, the vacancy-based promotion, is the only sacrosanct mean of career advancement, and there is nothing called time scale. This proceeds on this basis. I will deal with this through their document only when I comes to the reply. Then Acting Registrar BI informed the group of officers that DST, via its letter date number such and such, dated such and such, had approved for, even the 7 CPC was approved via 14th March 2018 letter for grant of 7 CPC with the following conditions. Roman 1, up to 70% of the likely expenditure to be incurred on implementation of the 7 CPC shall be borne by DST. Number 2, for waiver of remaining shortfall of 30% of the financial impact, Ministry of Finance approval is to be sought for bearing of the additional expenditure by the DST. Accordingly, BI had disbursed pay and allowances to its employees along with arrear with effect from such and such up to 70% as per the given condition in the DST letter dated such and such. The remaining 30% shall be disbursed as and when DST communicate the approval of the DOE to this effect. But after 2008 October, and this 7 CPC was even implemented on March 2018. And it's 70%. Now, next para. The Acting Registrar BI stated that non-academic technical employees of Bose Institute were being given timescale promotion since 22nd of December 2005. In terms of the revised pay structure and career advancement scheme of the non-academic staff, in support of his submission, he drew the attention of the group of officers towards DST OM dated at 8th of August 1979, wherein it was mentioned that there shall be pay parity between IACS and Bose Institute non-academic staff, and IACS, an autonomous institution having the approval of DST on the recommendation of the Structural Reforms Committee, had adopted the time scale promotion for its non-academic staff with effect from 22nd of December 2005. BI too followed in the footsteps of IACS. The issued BIOM dated 8th of April 2008 was having the approval of Finance Committee and the Governing Council of the BI dated 31st of January 2008 and 21st of March 2008 respectively. They missed on the 29th of October 2008, the most crucial. The document is there. I'll show in the next para. The document was there. Then next, The acting registrar, BI, also drawn attention of the group of officer about presence of Sri KP Pandian, the then joint secretary and financial advisor. Might kindly note this point. Same emphasis has been made by the Bose Institute before the group of officer. Well, this is not my stand. What I am placing before your lordship is the stand taken by the Bose Institute before the group of officer.
Yes.
The acting registrar also drawn attention of the group of officer about presence of Sri Pandian, the then joint secretary and financial advisor, and Sri Benjamin Lakra, the then AG West Bengal in finance committee meeting dated 31st of January 2008, and presence of Dr. T. Ramasamy and Sri S.C. Chawla, erstwhile secretary DST and director finance respectively in the governing council meeting dated such and such, in which the decision approval to this effect were taken granted. Now, my lord, next para. Professor Mishra and the staff representative present there contested that when the 6th CPC, my lord, Bose Institute is contesting.
Yes.
When the 6th CPC had been granted by the DST in the past on similar condition, then why at the first instance the matter this time had been referred to the group of officer for implementation of the 7th CPC? At 6th CPC, there was no disparity, so there was no occasion, rightly pointed out by the Bose Institute. My lord, I agree with them. Next para, my lord. In support of their contention, Bose Institute placed before the group of officers following document. My lord, now these series of documents, my lord, which I have placed before your lordship on the last day, just to show how, my lord, the sequence of events unfolded and how eventually the institution has lawfully implemented revised pay pattern and career advancement scheme in 2008. My lord, kindly take note of 3 documents, serial number 17, 18, and 19. My lord, serial 17 is copy of the finance committee meeting dated 7th January. My lord is aware of it.
Yes.
My lord, then again 21st of, they have not disclosed at 31st of January, but no, there is copy of minutes of extraordinary meeting of the finance committee. That is also there. Then minutes of the general governing council meeting, 21st March 2008, 178th meeting. And the most importantly, copy of minutes of governing council meeting dated 29th of October 2008. It is there. It is there, part of record. But I'll show to your lordship, there is no deliberation. There is no discussion. Even there is no whisper about this document in the entire purported deliberation carried out by the group of officers. Kindly take note of Roman 9, the 171st meeting. Next, group of officers found that some of the submissions made by the Bose Institute were without any supporting document. Hence, it was suggested that BI should furnish to the DST within 3 weeks' time the chronology of events that led to adoption of timescale promotion in lieu of vacancy-based promotion in the organization, along with justification available on record. Now, para 12. BI, by its letter dated 16th of July 2019, furnished detailed chronology of events as desired by the group of officers, along with supporting documents in addition to the documents already furnished in para 10 above. It has furnished the following document. Kindly see the document, my lord. The copy of the minutes of governing council meeting dated 17th April 2000, governing council meeting 18th December, governing council meeting 22nd of December 2001, to 17th of October 2004, 17th of September 2005, copy of Bose Institute's letter dated 23rd of December 2005, my lord, copy of letter issued by Dr. Hari Gopal, addressed to Director IACS, Kolkata, copy of DST OM dated 8th of August, my serial number 8, important, 8th of August 1979, wherein parity of the pay scale of non-academic staff of IACS and Bose Institute had been made with that of Calcutta University. My lord, Roman 9, letter addressed to Professor Barua from IACS. My lord, then copy of Bose Institute letter forwarding the recommendation of SRC to Bose Institute, SRC to Dr. Hari Gopal for approval of the competent authority, copy of minutes of the governing council meeting, 11th September, copy of email My lord, then minutes of finance committee meeting, important, my lord. 7th of December, January 2000, my lord, it should be 2008.
Yes,
Its typographical error appears to be. My lord, then this is important, kindly mark, my lord, 13 to 18. Copy of minutes of extraordinary general governing council meeting of Bose Institute dated 31st of January 2008. Copy of the minutes of governing council meeting dated 21st March, that is the 178th. Then my lord, 171st meeting, serial number 16. Copy of the group minutes of group governing council meeting of Bose Institute dated 29th October. Final recommendation of the structural reforms committee dated 7th July, 8th July 2006. Now, 18 is very important. Table showing the post, pay scales, residency period, and respective job responsibilities of various posts in Bose Institute vis-a-vis DRDO.
yes.
And this is the document they have called for. It is before them. Now, kindly have a look at the tabular statement. Tabular statement.
It was placed earlier.
Well, it was placed with respect to the technical employees.
Technical.
Now, my lord, kindly takes the first page itself, which is for the administrative cadre.
Yes,
But my clients are UDC 1, which my lord will find at page 2. My lord has that. Now, my lord, I'll just show what is the range of the petitioner, where they are employed. My lord, they are UDC 1 accountant. So, my lord, they are ranging from level 6, 7. My lord, kindly sees the second page. Office superintendent / accountant. The one of the petitioner before your lordship was enjoying the post designation of accountant before he was relegated back to his original post. But at level, at the that under the 6 CPC, it was 4,600.
yes,
Level 7, the residency period is 5 years.
5 years.
Well, now comes to the DRDO at the right hand side column. My lord. They call it administrative officer. My lord, the scale is 4,600. My lord, level 7. My lord, sees the residency period 3 years. PO central government employee at DRDO at the same designation is enjoying a residency period of 3 years, whereas my client is enjoying a residency period of 5 years. My lord, which is better? Who is standing at disparity? My lord, next takes the UDC clerk 1 stenographer, 4,200, level 6, 5 years. Right hand side column, my lord, senior administrative assistant, administrative superintendent, office superintendent, grade 1, 4,200, level 6, 3 years. Disparity is there, my lord. Truly disparity is there. But it is not tilted towards the central government employees. It is tilted towards my clients. If there is no disparity in the residency period, they are enjoying a better residency period than my client. And what could be the authority for the group of officer to even enter reference on this issue? This mapping was presented before them. I have shown to your lordship the very first paragraph of the reference of the group of officer report. That issue was that we were enjoying a better promotional revenue. Time scale, they called upon my clients, show the group of officer a tabular mapping that you don't enjoy a better facility. group of officers in their minutes of meeting 24th June themselves indicated you come up with a mapping with DRDO. We went there. We presented this document. After this document, they don't have the courtesy to even to convene a meeting and decide to take a call whether they have the jurisdiction or not. They went on with this futile exercise. What is the motive? I don't understand. This document is staring at their face. Next I'll place. Kindly take note of Roman 17 and Roman 16 and 18, my lord. These two are important documents which was not at all considered. And this is my strong, and this is one of my ground to challenge the recommendation made by the group of officers and the eventual impugned order which was passed by the authority. My lord. Next, my lord, para 15, or my lord 13. In addition to the submission made by the Bose Institute, the group of officers thought it prudent to consider as to whether such adoption of time scale promotion in respect of non-academic technical staff in lieu of vacancy-based promotion with effect from 22nd of December 2005 in Bose Institute wide OM number dated 8th April 2008 was implemented with the approval of the competent authority as contested by BI. Well, whether this is the issue? Can it be the issue which the group of officers is called upon to decide? It was not the issue. The sole purpose for which it was called upon is to find out whether there is disparity or not. And in case of disparity, you don't extend the financial package. Proposed financial package should not be in disparity with the central government. This is the limited scope. They don't have any authority to decide whether the 2008 policy in lieu of the time scale vacancy based promotion was lawfully implemented or not. Para 13. This is the scope that they have outlined for themselves. Their word here only. So, if the very issue that they decide or the scope they consider itself is wrong, all the subsequent deliberation, all the subsequent, my lord, discussion, it is misconceived. It's a futile exercise. They have misdirected themselves by putting this issue before themselves. And they cannot consider a policy which was implemented by the then secretary in 2008. Now, what is the composition of? It's a grave case of insubordination.
Yes.
Before my lord rises, I have come with a very innocuous prayer, my lord.
Just wait, let me finish this. Why are you so hurry?
Well, then I'll start with on the next day.
Next Thursday. Sixth. Sixth of March.
Grateful, my lord.
Argument on behalf of the petitioner hard in part. Let the matter appear in the list on 6th of March. Under the same head.
Lord, with regard to Lord, item number 7, Lord, thereafter, Lord, the same matter. Lord, after he finishes, Lord, Mr. Chakraborty is appearing. Pushpal Chakraborty is appearing. That
Item
matter-
number 5, 6 and
Eight,
7, we are
eight,
running
eight.
together.
Well, at 5, 6, 7 together. 8 hota tomato.
8. 8 is separate.
8 is separate.
8, Lord, Ongshuman Bhumik, 8.
Also one. 8 is separate.
Lord, I'm sorry, 8. 8 is
8.
separate.
8 are order. 8. Let the matter appear in the list on 6th. Under the same head.
Grateful one.
So grateful, my lord.
Another order হবে another করবে এটা তিনটে ফাইল হ্যাঁ order আলাদা করে করবে কালকে বড়টা হয়ে গেছে ওগুলো পাঠিয়ে দিচ্ছেন ওটা আমি বললাম কালকে আসেনি কেন বলবো নির্লজ্জের মতো ভাবলাম হ্যাঁ ওটা ওটা আজকে ফাইনাল করে দিতে আমি দিয়ে পাঠিয়ে দিচ্ছি
একসাথে দিচ্ছি।
ওটা সার্ভার করে দিতে। হুম ঠিক আছে
One humble request, one humble request for our purpose. Your lordship is passing, three orders together. Your lordship kindly passes to the separate order subject to the lordship kind sanction. This 4, 5, 5, 6, 7, your lordship is passing same order. If your lordship passes separate order.
Just one thing, since
you are arguing on behalf of 5
6, 7 minutes, I don't stand to this prayer, my lord, but only one request: let these three matters be tagged together, even if
it was
it should come
already
together.
tagged together
It was
একসঙ্গে যাতে থাকে লিস্টে, মানে একসঙ্গে আমরা,
অর্ডার করতে হবে
হ্যাঁ ঠিক আছে, বাট একসঙ্গে থাকে।
5 6
হ্যাঁ
7 and 8 চারটে অর্ডার হবে 5
আমার লাভ হলে
5 6 7 5 6 7 ফার্স্ট অর্ডার 5 6 7 ওটা ফার্স্ট অর্ডার তিনটে অর্ডার হবে 3 অর্ডার ঠিক আছে তিনটে আর নাম্বার গুলো দেবেন এইটা আলাদা এটা তো একই অর্ডার নয় তো আলাদা অর্ডার ডেট সেম ঠিক আছে
And so
ওকে ওকে হ্যাঁ হুম
Could your lordship kindly make your
which matter
keeping material lordship,
today it will be sir
Lordship, I am also in a similar pair, Lordship. He was present, Lordship. Item number 13 of yesterday's matter, Lordship. The order has not been uploaded till, Lordship. May kindly be uploaded.
item number
Item
30
number 13 of yesterday's list, Lordship. My learned senior was there as a respondent number 6, Lordship. I have made an application for appropriate order. The Lordship has
okay.
taken.
It will serve today also.
Yes.
আবার অর্ডার সার্ভার করতে হবে
2946
সার্ভার হয়ে গেছে বলছে
না 29
দাদা আপনিও সেম নাম দিয়ে দিন Mr. Nag, in your lordship.
But I am appearing for the petition item number 1. I am appearing for the petitioner.
Yes,
But the IOCL was making their submissions. But we have finished our submission on the last occasion. The IOCL was making their arguments. Today they are supposed to continue with their arguments.
Yes, only thing I was praying lordship for a passing. Nag was already rejected.
now if I took the item number 2, that will take entire day, entire half. Okay, so either you can start or you take adjournment. Mr. Nag supposedly concluded today.
Yes, he said he would conclude today. Yes. On the last date, he made his submissions and he said that he would conclude his arguments today.
Lordship, answer that
Today,
But could my learned friend use the microphone so that I can also hear her?
So I was thinking if
let me start item number 2 first.
yes,
Okay,
lordship, I
if
will
time
let you
permits, then I will start. Otherwise, next day.
next.
Okay.
The next day means tomorrow, but because worship takes up Friday also, the origin side matters.
Tomorrow I have to go to Bhopal. So
My lord, then
I-
next Thursday. If it is not taken up today, if Mr. Nag does not appear today, then my lord next.
I would only available for the first half.
My lord. So my lord, we can come back here next week if they do not make the submission today.
Appear on Thursday. Okay, usually appear on 6th.
6th. Then lordship would be kind enough to pass an order, my lord.
Lordship would not
Let the matter be adjourned for the
Matter.
time.
Well, let it be taken up at 2 p.m. next 6th. Let it be taken up at 2 p.m. my lord.
I usually appear at 2
Yes,
p.m.
order side matters are taken up to let it be item 1. Let it retain its position so that my matter can be disposed of by your lordship because
Very-
my lord is
very-
hearing the matter.
Item number 2.
Grateful to your lord. Grateful to your lordship.
May it please your lordship, my lord. This is a section 37 appeal which I am opposing. Kindly give me one moment. May I continue, my lord?
Yes.
Great. My lord, on the last occasion, I've been addressing your lordship for on several dates now, my lord. I will not do a recap today, my lord. I'll recap my arguments after I conclude. On the last occasion, your lordship may recall, I had shown some bills which Mr. Surana was relying on, or Mr. Sen was relying on, my lord, to show that I am in possession of the premises. And I showed your lordships, my lord, that those
Future
bills,
Retail Limited are in possession.
a different company altogether.
And you are Future Market Network. Limited.
That is right. The bills
It is your
also,
submission.
yes, the bills also show that, and the TDS certificates also being relied upon, they also show that. So nowhere am I in the picture,
Yes.
or rather those documents will not show that I am in possession.
Yes.
And that is in consonance with the award, which records that I have handed over possession. So therefore, the question of me continuing in possession cannot arise.
Yes.
Then, my lord, after I had shown placed those documents, my lord, I had shown some of the relevant paragraphs of the section 17 application, which was filed by Mr. Surana before the learned arbitrator. Lordship will recall, my lord, that this was titled, my lord, the cause title said it was an application under section 17 of the Arbitration and Conciliation Act, read with Order 38, Rule 5 of the Code of Civil Procedure. My lord, I've shown all those paragraphs, my lord, some of the paragraphs, my lord, which are relevant. May I continue, my lord, with the application and show a few more paragraphs, and then I will take your lordship through the impugned order. My lord will kindly take the application, which is in volume 2 of the stay petition. No, compilation of documents নেই ওই stay petitionটাতে আছে এইরকম দেখতে হ্যাঁ যেটা আনানো হয়েছিল ডিপার্টমেন্ট থেকে (145) volume 2. Lordship, my lord, has the application under section 17 read with order 38 rule 5.
Yes.
I had shown some of the paragraphs, my lord, the relevant paragraphs, my lord, showing, my lord, what are the documents he's relying on to claim that I'm in possession, how he's calculated the amounts which I'm supposedly liable to pay. Kindly, my lord, few more paragraphs, my lord. Kindly, my lord, turn to page 159, paragraph 23. Towards the bottom, my lord.
Yes.
My lord. My lord, before I place this paragraph, my lord, may I just remind your lordship, my lord, that Mr. Sen had made a particular argument as to how the corporate veil should be lifted. My humble submission in this regard is, my lord, twofold submission. One is, my lord, that this argument was not a part of his pleadings before the learned arbitrator. It was never his case before the arbitrator that the corporate veil should be lifted. Number one. So this entire section 17 application, your lordship will notice no mention of lifting of corporate veil, no such case made out. Second submission, in any event, in the alternative, this, my lord, case is not a case, my lord, for lifting the corporate veil. I'll make my legal submissions in respect of this little later.
Yes.
Kindly permit me to place paragraph 23 onwards, some of the paragraphs. The series of defaults committed by the respondent group companies and adverse steps taken by the security market regulator against the concerned persons at the helm of respondent group apparently reflects their depleted financial conditions. This certainly raises serious concerns as regards respondents' ability to honor any financial obligation which may arise from the conclusion of instant proceedings in the event of any favorable order being passed therein. Recently, the claimant has come to learn from filings made by the respondent number one, not me, my lord, but the other respondent, with the Bombay Stock Exchange and National Stock Exchange on 5th September 2021, that the respondent number one has suffered a loss of rupees 1056.06 crores during the previous financial year 2020 to 21. In yet another filing made by the respondent number two, my client, my lord, with the Bombay Stock Exchange and National Stock Exchange on 31st August 2021, together with their annual report for the year 2020 to 2021, wherefrom it would be seen that the said respondent has suffered a consolidated loss of rupees 3,078.77 during the previous financial year 2020 to 2021. Future Retail Limited, another company, my lord, has also filed a letter dated 4th September 2021, along with its annual report for the year 2020 to 2021 with the Bombay Stock Exchange and National Stock Exchange, wherefrom it would be seen that the company has suffered a loss amounting to rupees 3081.04 crores during the previous financial year 2020 to 2021. This company, my lord, Future Retail Limited, is not a party to this proceeding. But nonetheless, my lord, Mr. Surana is relying on the financial data or documents of this. Copy of relevant filings made by the respondents is annexed here too without annexure and collectively marked with the letter H. So far, my lord, as my client is concerned, in this paragraph, the allegation is
that I have suffered a consolidated loss of 3,078 rupees. That is, my lord, a negligible amount. In any event, my lord, if a company is running into loss, that, my lord, is not a ground for demanding security or attachment before judgment. Order 38, Rule 5 is very clear about the parameters in which respect of which an order of security can be passed. An order of security, my lord, in my humble submission, cannot be passed just because, assuming the worst, the company is not in good financial shape. That does not give rise to an order of attachment or order of security being passed. That is not a ground, a relevant ground. Next, my lord, para 24. The aforesaid subsequent filings reveal a pathetic and precarious state of financial affairs of the respondent companies, which may go bankrupt any day. So completely speculative, my lord. And thereby, there is every possibility and or likelihood that the award which is most likely to be passed in favor of the claimant will be rendered infructuous and or incapable of execution. Moreover, the respondents with the intent to obstruct and or delay execution of the award that is most likely to be passed in favor of the claimant would attempt to dispose of. Again, my lord, speculative. I have not made any such attempt, nor it is the claimant's case that such attempts have been made. Pure speculation, my lord. Would attempt to dispose of the whole or part of the property and or remove its properties, including monies in its bank account, to undisclosed locations and or accounts of its secret subsidiaries. I don't know what these secret subsidiaries are, my lord, but such is the pleading. These pleadings have been given, my lord, bald pleadings, my lord, to somehow satisfy the test of Order 38, Rule 5. That is why. But no substance, no evidence, no supporting proof in respect of such bald allegations. Para 25, my lord.
Yes.
The claimant, therefore, is entitled to and seeks an immediate order from the Honorable Tribunal to secure. He's an unsecured creditor at the highest, and he wants security in respect of his legal dues, which is an admitted claim. It is not admitted, amounting to rupees 51 crore 38,70,524 as on August 2021, detailed in paragraph 4J herein above, which I have already placed before your lordship, payable by the respondents on account of illegal occupation of the claimant's demised premises. It is submitted that the respondents have no defense to the claimant's admitted claim stated herein above. Such deposit be ordered to be made in cash and be placed at the disposal of the Honorable Tribunal. Now, my lord, will kindly turn to page 162, where the prayers are, my lord. Or my lord, kindly put the next page, my lord, just 2 or 3 more paragraphs, and then I'll go to the prayers. Kindly take para 27 on the next page.
Yes.
Your petitioner humbly submits that all these acts of the respondents clearly go to show that they are reeling under acute financial crisis and have indulged into fraudulent activities. From the documents and pleadings filed in Section 9 proceedings and also disclosed and made a part of the instant application, it is palpably clear that respondents have got no defense against the admitted claim raised by the claimant in the instant reference. Paragraph 28, your petitioner submits that he has reasons to believe that the respondents are purporting to transfer and or siphon of the monies lying in their bank accounts in order to make the award to be passed in favor of the claimant as nugatory and infructuous. Therefore, this Honorable Tribunal may be pleased to pass an ad interim order of injunction restraining the respondents from dealing with and or withdrawing any amount from its bank accounts without keeping apart a sum of rupees 51 odd crores till disposal of the instant proceeding. Paragraph 29, it is humbly submitted that the Honorable Tribunal may be pleased to direct the respondents to further show cause as to why the respondents should not be directed to furnish a cash security to the tune of such and such only, and to place the same at the disposal of this Honorable Tribunal. In the event the respondents fail to show cause and or adequate cause, the assets and properties of the respondents be attached before judgment. Now, my lord, the next page are the prayers, my lord. Kindly take 1 or 2 of the prayers, my lord. Prayer A, an order directing the respondents to furnish show cause as to why the respondents should not be directed to furnish a cash security to the tune of 51 crore 38,70,524 and to place the same at the disposal of this Honorable Tribunal. In the event the respondents fail to show cause and or inadequate cause, the assets and properties of the respondents be attached before judgment, ad interim order of injunction, etc., etc. So this is, my lord, what his prayers are, my lord. He is at the highest, my lord, an unsecured creditor claiming unliquidated damages, because what damages he suffered, if at all any, has to be asserted. These prayers, my lord, in my humble submission, cannot be considered in such an application filed by the claimant, and therefore it was rightly rejected by the tribunal. Now, lordship will kindly come to the impugned order, which is, my lord, at page 36 of volume 1. My lord, I will not trouble your lordship with the facts and the submissions which have been narrated here, but I will go straight, my lord, to the findings. Kindly give me one moment, my lord. Yeah, just a moment. Kindly come, my lord, to page 42.
Yes.
My lord, the third and the last paragraph, having regard to the respective submission. My lord, kindly come to the paragraph before that also, my lord, just to show, my lord, my argument of res judicata, and also to show that possession was an issue in the earlier arbitration. Learned advocate Mr. Medora further submits that principle of res judicata and our constructive res judicata and our issue estoppel will apply. As in earlier arbitral proceeding in between self-same parties, the finding is against the claimant regarding his claim that the respondents are in possession of the demise premises. Earlier arbitrator held that the third-party interest has already accrued by sub licensee in the demise premises on consent of the claimant. Hence, that finding of the earlier arbitral tribunal is binding on the principle of res judicata upon the present arbitral tribunal. Now, my lord, the findings. Having regard to the respective submission of the parties and considering the relevant judgments as referred to by the respective parties and the documents, namely the pleadings, affidavit in opposition, affidavit in reply, etc., it is evident that the respondents have relied upon the earlier arbitral proceeding in between the self-same parties with reference to self-same agreement and self-same demise premises, wherein a final award dated May 19, 2016 was passed, and wherein it is held, within quotation marks, the third parties are in possession of the demise property, and respondents justifiably contended that possession was in effect handed over on 19th April 2012. I think it should be 15th April, but be that as it may. And again, my lord, quoting from the award, the learned arbitrator does, the letter of termination of the agreement was issued by the respondents, and physical possession of the demise property could not be handed over due to the peculiar situation that sub licensees were in possession of the demise property who were running their own respective businesses. The order of Honorable Justice Moushumi Bhattacharya, as referred to earlier, wherein the application under Section 34 of the said Act, filed by the respondent number 2, a conditional order of stay of award impugned was passed, subject to deposit of amount as directed thereto to the Registrar Original Site, High Court at Calcutta. The said condition since has also not been fulfilled by the respondents, which is the positive submission of the parties and submission in their respective opposition. At present, there is no effect of stay of the award passed by the earlier arbitral tribunal held in between the self-same parties with reference to self-same agreement and self-same demise premises. Kindly mark the next few words, my lord. Hence, the finding of the earlier arbitral tribunal is binding to the present arbitral tribunal. Applying the principle of res judicata under Section 11 of the CPC as principle of CPC are applicable in the arbitral proceeding also is submission of respondents. It is contended that the possession of the respondents in the demise property was decided against the claimant in the earlier arbitral proceeding. Hence, claimant cannot claim for license fee alleging unauthorized occupation of the demise property by the respondents for the period as referred to above. The claimant's title as lessee also has been disputed by the respondent number 1 on categorically mentioning the issue by contending that the claimant did not execute the license agreement. It is the submission of the learned advocate for the claimant that earlier that issue was raised in title suit number 3193 of 2009 before the civil court at Aleppo, and an order dated 24th September 2017 was passed, holding inter alia that the termination letter issued by the railway was not effective, as the railway, after issuance of the said letter, passed different transaction in respect of the demised property, accepting the claimant as lessee. Be that as it may, hence it appears that a dispute of the title of the claimant as lessee and dispute about the occupation of the respondents of the demised property has been raised. So the arbitrator notes that there are triable issues, there are disputes. It is not an admitted position. It is also on record that one receiver has been appointed by the Debts Recovery Tribunal 3, Kolkata, in OA number 130 of 2010, with reference to a proceeding initiated by Union Bank of India against the claimant under the concerned act. Hence, the receiver is now custodian of the demised property. It is urged by the respondents that the claimant was a party to a meeting wherein the sub-licensees formed a union, namely Puja Mall Shop Owners Welfare Society, and agreed to the deposit of the rental or occupational charges or license fee to the receiver. Hence, applying the principle of custodia legis, a settled law, kindly mark the next few words, my lord. This honorable tribunal is of the view that the respondent's possession over the property required adjudication in main matter, and occupational charges as are being paid in the account of the claimant by depositing the same to the receiver by the sub-licensee also is required adjudication on taking evidence. So no scope, my lord, for interim relief at this juncture. Having regard to the documents which have been considered by this arbitral tribunal, it appears that claim of possession by respondents vis-a-vis claimant as lessee over the demised property requires further adjudication on merit, which cannot be done in section 17 application. The issues as raised are required to be considered at length at the time of final hearing, and prima facie, this honorable tribunal is not satisfied to pass any order in a proceeding under section 17 of the said act, which is for interim protection, where claimant has to satisfy prima facie about their claim and denial to make payment of such claims by the respondents. Hence, the application under section 17 of the said act stands dismissed. It is made clear that this honorable tribunal has not gone into merits of the legal principles as thrashed by respective parties, and parties are at liberty to urge all points at the final hearing of arbitral proceeding, except the points and issues already decided in application under section 16 of the Arbitration and Cancellation Act 1996, an award passed by arbitral proceeding on 19th May 2016. No order as to costs. So, my lord, this is the impugned order which is under challenge before your lordship today. Now, the learned arbitrator, in my respectful submission, considered and heard the parties in great detail, considered all the arguments made by both sides, the claimant on the one hand and the respondent numbers 1 and 2. And it came to the conclusion, it took a view, my lord, that no, there are serious issues which have been raised. It is not an open and shut case as the claimant is making it out to be. There are serious concerns as to who is in possession, particularly since the earlier arbitral award has held categorically that possession was handed over. There are issues in respect of the title of Mr. Surana. There is an unquantified claim. It's an unsecured claim. And therefore, the learned arbitrator was of the view that all this will require adjudication. I cannot pass any interim relief. But yes, Mr. Surana, I am not shutting out your case completely. Let there be trial. Let evidence be led. Thereafter, all these issues will be decided by me. This is what the view was taken, my lord. In my humble submission, this was a correct view, a fair view, a proper view. And section 37, my lord, as long as the arbitrator has taken a view which is reasonable, is not perverse, your lordship, even if your lordship has a different view, the arbitrator's view ought not to be submitted. So this is so far as the impugned order is concerned, my lord. Just 2 or 3 more documents I want to show your lordship, and then I'll take your lordship to the judgments I'm relying on. Kindly, my lord, take a compilation of documents which I had handed over, and I've shown, my lord, the final award from there. Just 2 documents I want to show, my lord, from there. Just 2 pages from this document, from this compilation. Kindly, my lord, take page 65. Lordship, my lord, has a letter written by the Union Bank of India, that is Mr. Surana's banker, in respect of this premises. Kindly see the date of this letter, 29th February 2012. This was, my lord, at the point of time when disputes were going on between, my lord, the claimant and the respondents, and just about a month and a half before we handed over possession to Mr. Surana, as has been held in the award. My lord, the bank is writing, my lord, to one of the shops which was carrying on its operations, my lord, at the concerned premises. Kindly see, my lord, who it is addressed to the manager, Cafe Coffee Day, coffee shop, my lord, Puja Mall, this is part of the demised premises, ground floor opposite Andhra Girls High School, Jhargram Road, Kharagpur. Kindly see the subject, it's a short letter, my lord. Enforcement action initiated by bank under securitization and reconstruction of financial assets and enforcement of Security Interest Act 2002 against Messrs. Mahavir Construction. That is Mr. Surana's proprietorship concern. Now, my lord, the letter, my lord, 2 paragraphs. We invite reference to our letter number such and such, dated 16th January 2012, wherein we had requested you to remit the rent to Union Bank of India, Strand Road branch, Kolkata. In this regard, we wish to inform you that on 24th February 2012, Subdivisional Officer Kharagpur had called a meeting wherein, apart from Honorable MP and MLA, representative of all the major political parties, AGRE, my predecessor in interest, Big Bazaar, Shop Owners Association of Puja Mall, Railway Authority, Electricity Department, etc. were present. In the meeting, it was informed by bank that bank is willing to defer further action in the matter if all the shop owners remit the rent directly to the bank, and the same was acceptable to the representatives of the Shop Owners Association. In view of the above, we request you to send us copy of the agreement you have entered into with Agre, that is my client's predecessor, my lord, because they were my sub-licensees. Coffee Day was my sub-licensee, and remit the rent exclusive of charges for common area maintenance and electricity charges by way of demand draft drawn in favor of Union Bank of India to Union Bank of India, Strand Road branch, such and such address. You can remit the rent payable also by RTGS NEFT, mentioning account number so and so. That is account of Messrs. Mahavir Construction. So the money which was to be remitted by all these occupiers would be to the credit of Mr. Surana. So instead of him receiving the rent through me, or me receiving the rents from my sub-licensees, the bank called upon all these occupants to pay the rent to them directly to the credit of Mr. Surana's occupation account. Mahavir Construction, address 12 Bonefield Lane, Kolkata 1, and IFSC code is so and so. Assuring you best of our cooperation and services, V.K. Srivastava, Chief Manager and Authorized Officer of the Union Bank of India. So, my lord, this will, my lord, substantiate my point as to how, my lord, the rents were now being paid directly to the bank. So, it is not a case that Mr. Surana...
Arrangement between the bank and the MLA, MPs and subdivisional officers.
Yes, and Mr. Surana was also present at the meeting.
It is not stated that Mahavir Construction was there.
Etc. is written, my lord, but that, my lord, the arbitrator in the award has considered that Mr. Surana was present at such meeting. I'll show one more document to my lord. Kindly take, my lord, the document at page 90. Copy. I have a better copy of this document. Kindly see this, my lord. This is that divisional officer, my lord, Lordship was referring to. Same, my lord.
Page?
This is, my lord, page 90.
90
of this compilation which your lordship is having. I've just handed over your lordship a cleaner copy. At least my copy, my lord, I can barely read it. I don't know if it's clearer in your lordship's copy.
Not clear.
That is why I handed over that page, my lord. Kindly see this letter, my lord. Since your lordship raised, my lord, the issue of the subdivisional officer, this will answer your lordship's query. Office of the Subdivisional Officer, Kharagpur, Paschim Medinipur. Minutes of the meeting held at the office of SDO Kharagpur on 7 March 2019 with all concerned to facilitate and sort out the issues related to electricity connection at Puja Mall and payment of dues to Union Bank of India. Now, let I place the minutes. The subdivisional officer took the chair and the meeting started. At first, SDO Kharagpur welcomed the members present, including, my lord, the developer, Mr. L.P. Surana,
Yes.
the Deputy General Manager of UBI, the Divisional Engineer, WBSEDCL, and other stakeholders having their commercial establishments at the Puja Mall and initiated the discussions. The Divisional Engineer, WBSEDCL, informed the House that he had already received an application from Mr. Surana on behalf of Mahavir Construction for giving electricity connection to the Puja Mall. He also informed that the connection will be given only after the security deposit is submitted by the applicant. The issue was discussed at large and the following resolutions adopted in presence of all concerned. Number 1, the security deposit shall be made before the WBSEDCL authority by the occupiers of Puja Mall through the Puja Mall Shop Owners Welfare Society. Second, the WBSEDCL shall arrange to install electrical connection after receiving of security deposit money and completion of other formalities within the earliest possible time. Number 3, the security deposit shall be made within 31st March 2019 and every occupier shall comply with the resolutions adopted unanimously. Number 4, kindly mark this, Vella, this is crucial because this ties in with the earlier document which I placed. After the electricity connections are made available, the occupiers shall make regular payments to the bank already due with it. So this is the arrangement. And last, my lord, this meeting was purely administrative in nature to facilitate the unresolved issues and shall have no other connection with any other litigation going on between Mahavir Construction and other stakeholders concerned. As there was nothing more to discuss, the meeting ended with thanks to and from the chair. It's signed by my lord on the right-hand side by the subdivisional officer. Kindly see the signature below that, my lord, Mr. Surana's signature. L.P. Surana, 8th of March 2019. And, my lord, there are various other stakeholders who have signed it, my lord. The Union Bank of India has signed it. Big Bazaar has signed it. Some exclusive storeroom has signed it. Mon Impression Shop has signed it. Khadim, the shoe company, has signed it. WBSEDCL has signed it. Some milkshake company has signed it. Some Titus company, I think it's a shoe company, they have signed it. One beauty parlor, Javed Habib, they have also signed it. So all the occupiers and all those who were present and the association of shop owners, they were present at this meeting. And this is the arrangement they entered into. And this document was amongst one of several documents other than the oral evidence, which was led and placed before the earlier arbitrator and relied upon to conclude that A, Mr. Surana entered into direct relationships with others. B, shop started paying rents directly to the bank. C, I had effectively handed over possession. So all this has been decided. This is just a document I'm showing your lordship in support of, my lord, the findings which were arrived at by the learned arbitrator.
Yes.
There are many more documents, but I will not trouble your lordship with that, my lord. Only the award is sufficient according to me, but just for your lordship's peace of mind, I have shown this document as well, in case your lordship had any doubt. So, my lord, these are the documents which I wanted to rely on, my lord. Now, my lord, I will take your lordship, my lord, to some of the judgments which I seek to rely on. Judgment copy the budget. My lord, there was a compilation of judgments made by me, my lord, a long time back, but which was not handed over. My lord, these are in addition, my lord, to the judgments which I've already placed when I had started my arguments with regard to the scope of section 37.
Yes.
These are in addition to that, my lord. You should have corrected it. My lord, these are 9 judgments, my lord. My lord, I've created an index on the second page and I've given, my lord, the proposition of law also. Well, just one small correction is perhaps required, my lord. In serial number 1, where, my lord, the judgment of Raman Tech is mentioned, paragraphs 4, 5, and 6 I'm relying on. Then, my lord, paragraph 10 onwards is referred to out there. that paragraph 10 onwards, special emphasis on paragraph 18 should actually be in respect of the second judgment, the Prem Raj Mundra. Whether in serial number 1, Raman Tech, Lordship has.
Paragraph 4, 5, and 6.
Yes, that is so far as.
Respect of Raman Tech.
Yes, and the next para 10 onwards, that should be, my lord, in respect of Prem Raj Mundra.
Very.
I apologize for this mistake.
No, take. Okay.
So, my lord, will kindly permit me, my lord, to place these judgments one by one, my lord. I have indicated, my lord, the headings out here, my lord, for your lordship's ease of reference on what propositions of law. My lord, 1, 2, 3, 4, 5, 6 propositions of law. I'm relying on 9 judgments, my lord. My lord, the first judgment is the Raman Tech judgment, my lord, on the principle of proposition that Order 38, Rule 5 is not maintainable before an arbitral tribunal in view of Section 17 of the Arbitration and Conciliation Act. Kindly, my lord, take the Raman Tech judgment, paras 4, 5, and 6, which is at page 3 of the compilation. My lord, what I should ideally do, my lord, is perhaps place the CPC once to show, my lord, what Order 38, Rule 5 is, and then come to this judgment. Order 38, Rule 5, my lord, very strict test, my lord. It is not for the mere asking.
Yes.
Attachment before judgment, Order 38, Rule 5. This is what the claimant relied upon before the arbitral tribunal. Where defendant may be called upon to furnish security for production of property. Sub-rule 1, my lord. Where at any stage of a suit, the court is satisfied by affidavit or otherwise that the defendant, with intent to obstruct or delay the execution of any decree that may be passed against him, is about to dispose of the whole or any part of his property, or B, is about to remove the whole or any part of his property from the local limits of the jurisdiction of the court may direct the defendant within a time to be fixed by it, either to furnish security in such sum as may be specified in the order, to produce and place at the disposal of the court, when required, the said property or the value of the same, or such portion thereof as may be sufficient to satisfy the decree or to appear and show cause why he should not furnish security. So, my lord, the tests are very strict, my lord. The plaintiff or the claimant, in this case, since it's an arbitration, he has to show that me as the defendant or the respondent, I am about to dispose of the whole or any part of my property. In his Section 17 application, there is only a bald allegation that I'm about to dispose of my property. But he's not been able to show, he's not been able to furnish even an iota of evidence that I'm about to dispose of any part or whole of my property. So he has not satisfied this test. The second test, that I am about to remove the whole or any part of my property from the local limits of the jurisdiction. This also, my lord, he has not shown anything. Furthermore, my lord, he has also to show that I have an intent, I have the intention to obstruct or delay the execution of any decree that may be passed.
Yes.
So it has to be a willful act that, look, I know that I am going to suffer a judgment, I am going to suffer a decree, I am going to suffer an award. Therefore, what do I do in order to make your award a paper award, make it infructuous? I will siphon away my assets at this point of time itself. I join issue here on 2 propositions or 2 counts, my lord. Firstly, my lord, he has not been able to prima facie satisfy that he is entitled to an award. And secondly, he has not been able to show that I have any intention to remove, or that I am removing or disposing of any of my property so as to defeat the so-called award which he may get. So that is Order 38, Rule 5, my lord. Now kindly, my lord, my judgment, my lord, paras 4, 5, and 6 of this Raman Tech judgment. Page 3, my lord, towards the top, paragraph 4.
Yes.
The object of supplemental proceedings, that is, applications for arrest or attachment before judgment, grant of temporary injunctions, and appointment of receivers, is to prevent the ends of justice being defeated. The object of Order 38 Rule 5, CPC in particular, is to prevent any defendant from defeating the realization of the decree that may ultimately be passed in favor of the plaintiff, either by attempting to dispose of or remove from the jurisdiction of the court his movables. The scheme of Order 38 and the use of the words to obstruct or delay the execution of any decree that may be passed against him in Rule 5 make it clear that before exercising the power under the said rule, the court should be satisfied that there is a reasonable chance of a decree being passed in the suit against the defendant. So some prima facie satisfaction must be there that yes, Mr. Surana is likely to succeed in his case. This would mean that the court should be satisfied that the plaintiff has a prima facie case. If the averments in the plaint and the documents produced in support of it do not satisfy the court about the existence of a prima facie case, the court will not go to the next stage of examining whether the interest of the plaintiff should be protected by exercising power under Order 38 Rule 5 of the CPC. It is well settled that merely having a just or valid claim or a prima facie case will not entitle the plaintiff to an order of attachment before judgment unless he also establishes. So two-pronged test, my lord. First, prima facie case, and second, over and above that, he also has to show what, my lord? Also establishes that the defendant is attempting to remove or dispose of his assets with the intention of defeating the decree that may be passed. Equally well settled is the position that even where the defendant is removing or disposing his assets, an attachment before judgment will not be issued if the plaintiff is not able to satisfy that he has a prima facie case. Paragraph 5 of this judgment, my lord. The power under Order 38 Rule 5 CPC is a drastic and extraordinary power. Such power should not be exercised mechanically or merely for the asking. It should be used sparingly and strictly in accordance with the rule. The purpose of Order 38 Rule 5 is not to convert an unsecured debt into a secured debt. My argument, my lord. Any attempt by a plaintiff to utilize the provisions of Order 38 Rule 5 as a leverage for coercing the defendant to settle the suit claim should be discouraged. Instances are not wanting where bloated and doubtful claims, Mr. Surana's claims are both bloated and doubtful, are realized by unscrupulous plaintiffs by obtaining orders of attachment before judgment and forcing the defendants for out-of-court settlements under threat of attachment. A defendant is not debarred from dealing with his property merely because a suit is filed or about to be filed against him. Shifting of business from one premises to another premises or removal of machinery to another premises by itself is not a ground for granting attachment before judgment. A plaintiff should show prima facie that his claim is bona fide and valid, and also satisfy the court that the defendant is about to remove or dispose of the whole or part of his property with the intention of obstructing or delaying the execution of any decree that may be passed against him before power is exercised under Order 38 Rule 5 of the CPC. Courts should also keep in view the principles relating to grant of attachment before judgment. See Premraj Mundra versus Muhammad Manek Ghazi for clear summary of the principles. This is, my lord, a Calcutta High Court judgment, and it's a matter of great pride, my lord, where the Supreme Court relies on the Calcutta High Court judgment and says that look at this judgment for a clear summary of the principles. And that is the second judgment which I'm going to rely on, my lord, which is at page 5 of this compilation. Kindly take para 10 onwards of this judgment, which is, my lord, at page 8 of this compilation.
Yes.
So this is Premraj Mundra versus Manek Ghazi, reported in so-and-so. Para 10 onwards. Para 10 to... Actually, my lord, I won't... Let me travel. In this case also, the relevant paras of the affidavits were verified, true according to information, inquiry, and belief, but the sources of grounds thereof were not disclosed. And actually, my lord, we can skip some of the paragraphs, my lord, just to cut short the matter. Otherwise, my lord, it'll get a little boring. I will kindly come to paragraph 18. Let me not trouble your lordship too much, my lord. Kindly come to paragraph 18 at page 11.
Yes.
From a perusal of all the authorities. So para 10 onwards, my lord, discusses and deals with all the authorities, and they are now nicely summarized here. I think that the following guiding principles can be deduced. And my lord, I think 14 such guiding principles were deduced, which the Supreme Court also says is very clear. First, that an order under Order 38, Rule 5 and 6 can only be issued if circumstances exist as are stated therein. Number two, whether such circumstances exist is a question of fact that must be proved to the satisfaction of the court. Number three, that the court would not be justified in issuing an order for attachment before judgment or for security merely because it thinks that no harm would be done thereby or that the defendants would not be prejudiced. Number four, that the affidavits in support of the contentions of the applicant must not be vague. In our case, it's absolutely vague and must be properly verified. Where it is affirmed true to knowledge or information or belief, it must be stated as to which portion is true to knowledge, the source of information should be disclosed, and the grounds for belief should be stated. Number five, that a mere allegation that the defendant was selling off his properties is not sufficient. Particulars must be stated. Number six, there is no rule that transactions before suit cannot be taken into consideration, but the object of attachment before judgment must be to prevent future transfer or alienation. Number seven, where only a small portion of the property belonging to the defendant is being disposed of, no inference can be drawn in the absence of other circumstances that the alienation is necessarily to defraud or delay the plaintiff's claim. Number eight, that the mere fact of transfer is not enough, since nobody can be prevented from dealing with his properties simply because of a suit has been filed. There must be additional circumstances to show that the transfer is with an intention to delay or defeat the plaintiff's claim. It is open to the court to look to the conduct of the parties immediately before the suit and to examine the surrounding circumstances to draw an inference as to whether the defendant is about to dispose of the property, and if so, with what intention. The court is entitled to consider the nature of the claim and the defense put forward. Number nine, kindly make a note of this, my lord. The fact that the defendant is in insolvent circumstances or in acute financial embarrassment is a relevant circumstance, but not by itself sufficient. Number 10, that in the case of running businesses, the strictest caution is necessary, and the mere fact that a business has been closed or that its turnover has diminished is not enough. Number 11, where, however, the defendant starts disposing of his properties one by one immediately upon getting a notice of the plaintiff's claim, and or where he had transferred the major portion of his properties shortly prior to the institution of the suit and was in an embarrassed financial condition, these were grounds from which an inference could be legitimately drawn that the object of the defendant was to delay and defeat the plaintiff's claim. Number 12, mere removal of properties outside jurisdiction is not enough, but where the defendant, with notice of the plaintiff's claim, suddenly begins removal of his properties outside the jurisdiction of the appropriate court and without any satisfactory reason, an adverse inference may be drawn against the defendant. Where the removal is to a foreign country, the inference is greatly strengthened. Number 13, the penultimate one. The defendant under a suit, in a suit, is under no liability to take any special care in administering his affairs simply because there is a claim pending against him. Mere neglect or suffering execution by other creditors is not a sufficient reason for an order under Order 38 of the Code. Number 14, lastly, the sale of properties at a gross undervalue or benami transfers are always good indications of an intention to defeat the plaintiff's claim. The court must, however, be very cautious about the evidence on these points and not rely on vague allegations. Very clear, my lord, the principle. Very high standard, very high test has to be satisfied. In my respectful submission, the appellant before your lordship has not met any of these criteria or tests or conditions which have been prescribed. No case, no prima facie case, not able to show that I have any intention to defeat the so-called award he may get, no intention. And lastly, my lord, most importantly, I have not taken any step to dispose of anything other than a vague or bald allegation against me that I am disposing of. I will send it to my secret subsidiaries. Who are these secret subsidiaries? Lordship is not being called upon to be James Bond out here and investigate as to who the secret agents and secret subsidiaries are. So, my lord, the next judgment which I will seek to rely on, my lord, is on the proposition that there cannot be any claim for unliquidated damages giving rise to any debt unless the same is adjudicated upon. Kindly, my lord, take the judgment beginning at page 14 of this compilation. My lord, Union of India versus Raman Iron Foundry, and I seek to rely on para 11 of this judgment, which is at page 26, my lord. Lordship will see at the top, just for curiosity's sake, this judgment was printed on May 18, 2022, when we were arguing the matter before the learned arbitrator. So these judgments were placed then. And I'm still relying on the judgment before your lordship. Kindly, take paragraph 11.
Yes.
Having discussed the proper interpretation of clause 18, we may now turn to consider what is the real nature of the claim for recovery of which the appellant is seeking to appropriate the sums due to the respondent under other contracts. The claim is admittedly one for damages for breach of contract between the parties. Now, it is true that the damages which are claimed are liquidated damages under clause 14, but so far as the law in India is concerned, there is no qualitative difference in the nature of the claim, whether it be for liquidated damages or for unliquidated damages. Section 74 of the Indian Contract Act eliminates the somewhat elaborate refinements made under the English common law in distinguishing between stipulations providing for payment of liquidated damages and stipulations in the nature of penalty. Under the common law, a genuine pre-estimate of damages by mutual agreement is regarded as a stipulation naming liquidated damages and binding between the parties. A stipulation in a contract in terrorism is a penalty, and the court refuses to enforce it, awarding to the aggrieved party only reasonable compensation. The Indian legislature has sought to cut across the web of rules and presumptions under the English common law by enacting a uniform principle applicable to all stipulations, naming amounts to be paid in case of breach and stipulations by way of penalty. And according to this principle, even if there is a stipulation by way of liquidated damages, a party complaining of breach of contract can recover only reasonable compensation for the injury sustained by him, the stipulated amount being merely the outside limit. It therefore makes no difference in the present case that the claim of the appellant is for liquidated damages. It stands on the same footing as a claim for unliquidated damages. Now, the law is well settled that a claim for unliquidated damages does not give rise to a debt until the liability is adjudicated and damages assessed by a decree or order of a court or other adjudicating authority. Now, this line is very crucial, my lord, because Mr. Sen had argued that your license agreement talks about a specific sum of rent, so therefore it is liquidated, therefore you have to give me this. But Indian law, my lord, makes no difference between liquidated and unliquidated. In any case, it has to be ascertained. Today, there is no agreement between the two of us. So you cannot rely on an agreement which has come to an end to say that it is liquidated. But be that as it may, my lord. When there is a breach of contract, the party who commits the breach does not, eo instanti incur any pecuniary obligation, nor does the party complaining of the breach become entitled to a debt due from the other party. The only right which the party aggrieved by the breach of the contract has is the right to sue for damages. That is what Mr. Surana is suing me for. That is not an actionable claim, and this position is made amply clear by the amendment in Section 6E of the Transfer of Property Act, which provides that a mere right to sue for damages cannot be transferred. This has always been the law in England, and as far back as 1858, we find it stated by Justice Whiteman in Jones versus Thompson. Ex parte Charles and several other cases decide that the amount of a verdict in an action for unliquidated damages is not a debt till judgment has been signed. It was held in this case that a claim for damages does not become a debt even after the jury has returned a verdict in favor of the plaintiff till the judgment is actually delivered. So also in such and such case, Lady Justice so-and-so said, in reference to cases where the claim was for unliquidated damages, in such cases, there is no debt at all until the verdict of the jury is pronounced, assessing the damages, and judgment is given. The same view has also been taken consistently by different high courts in India. We may mention only a few of the decisions, namely such and such, such and such, such and such. Chief Justice Chagla, in the last mentioned case, stated the law in these terms. And it's quoted, my lord, Justice Chagla's lines. In my opinion, it would not only be true to say that a person who commits a breach of the contract incurs any pecuniary liability, nor would it be true to say that the other party to the contract who complains of the breach has any amount due to him from the other party. As already stated, the only right which he has is the right to go to a court of law and recover damages. Now, damages are the compensation which a court of law gives to a party for the injury which he has sustained. But, and this is most important to know, he does not get damages or compensation by reason of any existing obligation on the part of the person who has committed the breach. He gets compensation as a result of the fiat of the court. Therefore, no pecuniary liability arises till the court has determined that the party complaining of the breach is entitled to damages. These words are important, my lord. Therefore, when damages are assessed, it would not be true to say that what the court is doing is ascertaining a pecuniary liability which already existed. The court in the first place must decide that the defendant is liable, and then it proceeds to assess what that liability is. But till that determination, there is no liability at all upon the defendant. And I respectfully say that in this case, my lord, no liability on me as on this moment. This statement, in our view, represents the correct legal position and has our full concurrence. Supreme Court is saying this, my lord. A claim for damages for breach of contract is therefore not a claim for a sum presently due and payable, and the purchaser is not entitled, in exercise of the right conferred upon it under Clause 18, to recover the amount of such claim by appropriating other sums due to the contract. On this view, it is not necessary for us to consider the other contention raised on behalf of the respondent, namely that on the proper construction of Clause 18, the purchaser is entitled to exercise the right conferred under that clause only where the claim for payment of a sum of money is either admitted by the contractor or, in case of dispute, adjudicated upon by a court or other adjudicatory authority. We must therefore hold that the appellant had no right or authority under Clause 18 to appropriate the amounts of other pending bills of the respondent in or towards satisfaction of its claim for damages against the respondent, and the learned judge was justified in issuing an interim injunction restraining the appellant from doing so. We accordingly dismiss the appeals. The appellant in each appeal will pay costs of the respondent all throughout. So, my lord, therefore, today, my lord, based on this judgment, my lord, my submission is that as on date, my lord, there is no debt of the respondents. If at all there is a debt, it has to be ascertained. And that ascertainment can only take place after a full and conclusive trial before the learned arbitrator. So if there is no debt, the question of me being directed to pay any money to Mr. Surana cannot arise. Similarly, if there is no debt as on this date, the question of me giving any security also to Mr. Surana does not and cannot arise. Now, my lord, the fourth judgment I think I've already placed. Manish Agarwal versus RCI Industries. I will not trouble your lordship with that again. I had shown this judgment and some more judgments, my lord, on section 37. So kindly ignore this judgment for now, but it is there. Kindly take, my lord, the next judgment at serial number 5 of my index, Nimbus Communications, on the proposition that Order 38 Rule 5 principle would serve as a guiding principle while exercising jurisdiction under Section 9 of the Arbitration and Conciliation Act, and Section 17, my lord, is similar to Section 9. Kindly, my lord, take this judgment, which starts at page 39 of my compilation. And I rely on, my lord, paras 22, 23, and 24 of this judgment. Para 22 starts, my lord, at page 50 of my compilation.
Paragraph
22, 23, and 24. Commencing, my lord, at page 50 of this compilation. Let's commence with placing para 22. The judgment of the Supreme Court in Adunik Steels has noted the earlier decision in Arvind Constructions, which holds that since Section 9 is a power which is conferred under a special statute, but which is exercisable by an ordinary court without laying down a special condition for the exercise of the power or a special procedure, the general rules of procedure of the court would apply. Consequently, where an injunction is sought under Section 9, the power of the court to grant that injunction cannot be exercised independent of the principles which have been laid down to govern the grant of interim injunctions, particularly in the context of the Specific Relief Act of 1963. The court, particularly in the context of the Specific Relief Act, the court consequently would be obligated to consider as to whether there exists a prima facie case, the balance of convenience, and irreparable injury in deciding whether it would be just and convenient to grant an order of injunction. Section 9 specifically provides in subclause D of clause 2 for the grant of an interim injunction or the appointment of a receiver. As regards subclause B of clause 2, the interim measure of protection is to secure the amount in dispute in the arbitration. Now, my lord, Order 38, Rule 5. The underlying object of Order 38, Rule 5 is to confer upon the court an enabling power to require a defendant to provide security of an extent and value as may be sufficient to satisfy the decree that may be passed in favor of the plaintiff. The exercise of the power to order that security should be furnished is, however, preconditioned by the requirement of the satisfaction of the court that the defendant is about to alienate the property or remove it beyond the limits of the court with an intent to obstruct or delay execution of the decree that may be passed against him. In view of the decisions of the Supreme Court, both in Arvind Constructions and Adunik Steels, it would not be possible to subscribe to the position that the power to grant an interim measure of protection under Section 9, subsection 2b is completely independent of the provisions of the Code of Civil Procedure 1908, or that the exercise of that power is untrammeled by the court. In other words, the court will apply. The basic principle which emerges from both the judgments of the Supreme Court is that though the Arbitration and Conciliation Act 1996 is a special statute, Section 9 does not either attach a special condition for the exercise of the power, nor does it embody a special form of procedure for the exercise of the power by the court. The second aspect of the provision, which has been noted by the Supreme Court, is the concluding part of Section 9, under which it has been specified that the court shall have the same power for making orders as it has for the purpose of and in relation to any proceedings before it. This has been interpreted in both the judgments to mean that the normal rules that govern the court in the grant of an interlocutory order are not jettisoned by the provision. The judgment of the division bench of this court in National Shipping Company notes that though the power by section 9(2)(b) is wide, it has to be governed by the paramount consideration that a party which has a claim adjudicated in its favor ultimately by the arbitrator should be in a position to obtain the fruits of the arbitration while executing the award. The division bench noted that the power being of a drastic nature, a direction to secure the amount claimed in the arbitration petition should not be issued merely on the merits of the claim unless a denial of the order would result in grave injustice to the party seeking a protective order. The obstructive conduct of the party against whom such a direction is sought was regarded as being a material consideration. No obstructive behavior by me in this case, my lord. However, the view of the division bench of this court that the exercise of power under section 9(2)(b) is not controlled by the provisions of the Code of Civil Procedure 1908 cannot stand. That means it will apply in view of the decision of the Supreme Court in Adhunik Steels. Paragraph 23. In a recent judgment of a learned single judge of the Delhi High Court in Steel Authority of India Limited versus AMSIPTI Limited, decided on 1st September 2011, the judgment of the division bench of this court in National Shipping Company was relied upon. The Delhi High Court observed that the provisions of Order 38 Rule 5 would serve as a guiding principle for the exercise of the jurisdiction while dealing with a petition under Section 9, requiring the respondent to furnish security, and the basic consideration is that the court should be satisfied that furnishing of security is essential to safeguard the interest of the petitioner. The last paragraph which I seek to rely on from this judgment, my lord, para 24. A close reading of the judgment of the Supreme Court in Adhunik Steels would indicate that while the court held that the basic principles governing the grant of interim injunction would stand attracted to a petition under Section 9, the court was of the view that the power under Section 9 is not totally independent of those principles. In other words, the power which is exercised by the court under Section 9 is guided by the underlying principles which govern the exercise of an analogous power in the Code of Civil Procedure 1908. The exercise of the power under Section 9 cannot be totally independent of those principles. At the same time, the court, when it decides a petition under Section 9, must have due regard to the underlying purpose of this conferment of the power upon the court, which is to promote the efficacy of arbitration as a form of dispute resolution. Just as on the one hand, the exercise of the power under Section 9 cannot be carried out in uncharted territory, ignoring the basic principles of procedural law contained in the Code of Civil Procedure 1908, the rigors of every procedural provisions in the Code of Civil Procedure 1908 cannot be put into place to defeat the grant of relief, which would subserve the paramount interests of justice. A balance has to be drawn between the two considerations in the facts of each case. The principles laid down in the Code of Civil Procedure 1908 for the grant of interlocutory remedies must furnish a guide to the court when it determines an application under Section 9 of the Arbitration and Cancellation Act 1996. The underlying basis of Order 38 Rule 5, therefore, has to be borne in mind while deciding an application under Section 9(2)(b). And my submission is, my lord, 9(2)(b) is akin to Section 17, so the same principles will also necessarily apply to an application under Section 17. The only difference between 9 and 17 is 9 you go before the court, 17 you go directly before the arbitrator. Powers otherwise are the same. Now, my lord, the next judgment which I seek to rely on, my lord, are on the propositions of implied surrender under Section 111F of the Transfer of Property Act. Because Mr. Surana and Mr. Sen have been continuously saying, how did it not give vacant possession, etc., etc. Though the award holds to the contrary, nonetheless, my lord, to bolster my claim and submission, three judgments which I seek to rely on, my lord. The first judgment, my lord, is at page 56 of this compilation, Supreme Court judgment. We have the TP Act. Well, before I show this judgment, kindly permit me to place section 111 F of the Transfer of Property Act.
Yes.
Have it? My lord, I'll show it later, my lord, I'm not carrying the book. Kindly permit me to place the judgment, my lord. Page 56 onwards is the judgment. And the relevant paragraph is, my lord, para 10, which is, my lord, at page 63. May I please, my lord? Under clause F of section 111 of the Transfer of Property Act 1908, implied surrender is a mode for determination of a lease of immovable property. In English law, delivery of possession by the tenant to a landlord and his acceptance of possession effects a surrender by operation of law. It is also called implied surrender in contradistinction to express surrender, which must be either by deed or in writing. It has been held, my lord, you kindly mark the next few words, my lord, that is relevant for our case. It has been held that directing the occupier, my sub licensee, to acknowledge the landlord, Mr. Surana, as his landlord, that is to atone to the landlord, is a sufficient delivery of possession by the tenant to the landlord. This is exactly what has happened in our case, my lord. Mr. Surana gave me the property. I gave the property to certain people below me. Those people have now acknowledged Mr. Surana as the landlord, and likewise, Mr. Surana has acknowledged them as his licensees or lessees. And that will constitute, my lord, me handing over possession to Mr. Surana. Lord, I'll read this once again, matter. It has been held that directing the occupier to acknowledge the landlord as his landlord, that is to atone to the landlord, is a sufficient delivery of possession by the tenant to the landlord. It has also been held that receipt of rent from a person in possession may be evidence of the landlord's acceptance of him as tenant, whether he is a stranger or whether he was already in possession as subtenant. This also, my lord, is very relevant to our case, my lord, because Mr. Surana, through his bank, is accepting rents from these occupants. So that also shows, my lord, how possession has indeed been handed over, and he has a separate direct relationship between himself and the current and present occupiers. And I am, my lord, out of the picture. So, my lord, I'll just read the second line once again, my lord. It has also been held that receipt of rent from a person in possession may be evidence of the landlord's acceptance of him as tenant. So he's accepting him as tenant. The occupiers, cafe, coffee day, etc., etc. Whether he is a stranger, in this case, he's not a stranger, or whether he was already in possession. Yes, cafe, coffee day, etc. were already in possession as a subtenant. Under the illustration to clause F of section 111 of the Transfer of Property Act, there would be an implied surrender of the former lease if a lessee accepts from his lessor a new lease of the property leased to take effect during the continuance of the existing lease. The said illustration is, however, not exhaustive of the cases in which there may be an implied surrender of the lease, just as under the English law, there can be implied surrender under the law of transfer of property in India if the lessor grants a new lease to a third person with the assent of the lessee under the existing lease who delivers the possession to such person, or where the lessee directs his subtenant to pay the rent directly to a lessor. Well, just to place section 111 F, section 111 of the Transfer of Property Act, my lord, talks about, the heading is determination of lease. A lease of immovable property determines, F says, by implied surrender. So that is the case which is made out by me. And it has been accepted by the arbitrator. Well, this is one judgment, my lord. Two more judgments on this point, my lord. The next judgment, my lord, is at page 66. Vijendra Narayan Roy versus Jogesh Chandra Dev. An old Calcutta High Court decision. Starts at page 66 and para 12 is at, my lord, is at page 76.
Yes.
May I just place this one paragraph, my lord? As regards the contention of the second defendant that he is not at all liable for mean profits.
You are referring paragraph
12, my lord,
12.
at page 76 of the compilation.
Yes.
As regards the contention of the second defendant that he is not at all liable for mean profits, we are of the opinion that he is liable to the extent stated by the subordinate judge, namely from 95th, should be some other day, 15th maybe, my lord, May 1915, when he took leases from the first defendant and entered into possession. He never relinquished possession, and the subordinate judges has correctly found that the first two defendants combined to keep the plaintiff out of possession. The attempt made by the second defendant to evade liability for mean profits is bound to end in failure. There is, however, one point in connection with the order for mean profits which has been overlooked by the court below. During the pendency of this litigation, a receiver was appointed on the 12th of November 1921, and the receiver, we have been informed, is still in possession. When the court has appointed a receiver, the receiver is in possession, and the receiver is in possession. His possession is the possession of the court, and the possession of the court by its receiver is the possession of all parties to the action according to their titles. Such and such cases are cited. The property passes into legal custody as the receiver is in the possession of stakeholder, and such custody is for the benefit of the true owner. From this, it follows that the liability of the defendants for mean profits terminated on 12th November 1921, and from that date, the plaintiff, if successful, would be entitled only to such sums as might be in the hands of the receiver. Consequently, the dash of the subordinate judge must be amended by substitution of the word such and such, 11th November 1921, for such and such, to the date of the plaintiff getting such and such, or till the expiry from the date of decree, whichever event occurs first. So, my lord, this is a point, my lord, on custodia legis. In our case, my lord, also lordship has seen that a receiver was appointed by the debt recovery tribunal. So, my lord, once a receiver is appointed, in any event, my lord, as per this judgment, the possession now belongs to the court. The receiver is in custodia legis. So, in any event, this is my second or third argument in the alternative, that in any event, my lord, I cannot be said to be in possession. If at all anybody is in possession, it is the receiver. And my lord, becomes very clear, my lord. If the plaintiff is successful, he will be entitled only to such sums as might be in the hands of the receiver. So not from the occupiers as such, because the receiver is in possession. This point, my lord, of custodia legis, my lord, was also noted by the learned arbitrator in the order which has been impugned before your lordship. My lord, the third and last judgment which I seek to rely on, my lord, on this issue, my lord, is at page 80. Again, my lord, a Calcutta decision, 1986. Justice A.M. Bhattacharjee. I had the good fortune, my lord, of having a few classes in law being taken by him when I was in college. Justice A.M. Bhattacharjee. My lord, kindly permit me to rely on paragraphs 5 and 5A of this judgment, which is at page 81. If the matters stood at that only, then under the decree of the learned trial judge for mean profits, from the date of expiry of the lease till recovery of possession, which was also confirmed by this court, the plaintiff would have been entitled to mean profits for the entire period till such recovery of possession. But when the matter came back to the court below, the court, while determining the quantum of mean profits, took notice of the fact that in the suit, even before the preliminary decree was passed, a receiver was appointed, though it was the defendant who was appointed as the receiver, and the court below thought that in view of having been appointed such a receiver, the defendant could no longer be liable to pay mean profits after such appointment, even though the defendant itself was the receiver. This is on a higher pedestal, my lord. If this is the right view, the plaintiff's appeal shall fail. We have no doubt that the court below was right. Para 5A. Against this, the plaintiff has filed FA number 237, while the defendant has filed appeal being FA number 238 against the decree of mean profits, even for the period up to its being appointed as a receiver. As we have noted at the outset, wrongful possession is the sine qua non, the very essence and the sole foundation for a claim of mean profits, and a judgment debtor can never be saddled with the liability if or mean profits unless his possession is wrongful in law. Mr. Dasgupta, the learned advocate for the judgment debtor, has drawn our attention to an old bench decision of this court in Indurjit Singh versus Babu Radhe Singh, reported in such and such, where Justice Fear observed that generally, from the nature of claim to mean profits ought not to be estimated for any period during which the defendant, who is to be made responsible for them, was not active in keeping the plaintiff out of possession. These observations have been quoted with approval in a later bench decision of this court in Chaganmal Agarwal versus Amantalia, reported at so-and-so, to which also our attention has been drawn by Mr. Dasgupta. In this case, since the date of the defendant being appointed as a receiver by the court, it was the court through the defendant as its officer and not the defendant itself who kept the plaintiff out of possession. So in our case also, my lord, receiver has been appointed. Our case is slightly better. The respondent was not appointed as the receiver. It was an independent third party who was appointed as a receiver. Lordship is possibly rising. I will take only about 10 to 15 minutes on the next date. One more judgment and one legal submission and I'll conclude, my lord.
Next Thursday.
Kindly give me one moment, man. I think it should be fine. Next Thursday, quarter date. Very well, my lord. Next Thursday.
Okay. Argument on behalf of Mr. Medora, hard in part. Let Mr. Medora, argument on behalf of Mr. Medora, hard in part. Let the matter appear in the list on 6th of March at 2 p.m.
Grateful, my lord.
The application I have filed listed today. Can you see that?
Stay আছে কত নম্বর? Okay.
I supplied copy to the other side also.
Have you served copy?
Yes, I have received a copy and I would, my lord, like to file an opposition to the same.
Okay, let the matter appear on Thursday. Next Thursday it will appear. Next Thursday.
Tomorrow, may not I have that my section 34 application.
Now tomorrow I am not able to sit in second half. I have some other place I have to go.
So then it can be heard on which day, Mega?
Tomorrow.
No,
Tomorrow the matter
your-
fixed on tomorrow.
But tomorrow your lordship would not be there. The mine this 34 application, then it can be heard then. Next Friday.
Friday.
Next Friday.
Friday. Thursday না Friday তো করা আছে। Next Thursday করা আছে। Friday আছে। Tomorrow it was fixed.
Tomorrow it is fixed, my lord.
Tomorrow it was fixed.
It
Tomorrow.
will automatically come in the list next Thursday, then possibly.
Next Thursday it will appear.
Next Thursday.
A list should be appear.
Next Thursday.
Next Thursday.
But another thing, my application is 137. Mr. Medora's application is 135. There's another application also 136. So 136, certain documents I will be referring. So 136 may also be kindly brought in so that I can refer to those.
You want to rely some documents?
When?
When? At the time of argument?
When I will be making my submissions in respect of my application.
Okay. But any other? Right.
Copy.